Good morning, Justice Madlanga.
Good morning, President Petse, Chair.
Are you well this morning?
I am, thank you very much, Deputy President. Did I say President earlier?
Yes, you did.
I don't think it's bad to promote you, but Deputy President.
Thank you. I'll afford you a few minutes to settle down, and please give me a signal when you are ready. Then we'll commence with the interview.
I am ready, Deputy President.
Thank you, Justice Madlanga.
Thank you.
Could we, first and foremost, establish your true identity? When the program for today was prepared, I observed that your initials were MRW. And when I queried that with the Secretariat, before I had sight of the papers, I was told that the source of that was your curriculum vitae.
The W is one of my given names, Deputy President, but I discarded it in my ID, but I guess out of what respect for my late father, we used to have a joke at home that he would give us names, the first name of a white person and that white person's surname. Like, fine, I have my Xhosa name, Buisele, but then he also gave me the names Russell Wilberforce. And the firstborn at home is Faith Rosalind. Then there's Windsor Winifred, Parksley Farewell, and so on. So we had that joke about first name and surname of white people.
Thank you, Justice Madlanga. I hope that the Office of the Chief Justice has taken note of that, and they should then convey that information to PESA. Thank you. Could you please take a few seconds, look around this table, and see if you know most, if not all, of the members of the commission here present?
I've seen the face. I don't really watch, but I will sometimes have glimpses of the interviews. I have seen some of the faces, but definitely I do know some of the people, of the commissioners, I'm sorry, and I know some of them very well, and I'm sure that some of them are going to do what one of my teachers used to caution against I'm sorry to waste your time, Deputy President, when we were debating at Mariazell High School, and then when you came after your opponent, Sister Benedette would say, Muni vrakniem kennersne, muni vrakniem, which means don't revenge or avenge yourself against your opponent. So I'm sure some of the commissioners here will want to do that. And may I request the two at the corner there, please not to do that.
Thank you, Justice Madlanga. Speaking for myself, I have to declare that I have known you for some, I think, 40 years.
It's a very long time.
And my first encounter with you was in the Mthatha Magistrates Court, where I appeared in a matter as a defense attorney. You were prosecuting, and the presiding magistrate, Mr. Houston Barnes, rebuked me for addressing you as my learned friend. And when I asked him why, his retort was that he is not learned. You mustn't address him as your learned friend.
I remember that, Deputy President.
First and foremost, I want to mention that you are the first of the 4 candidates nominated by the President of the Republic of South Africa for the position of the next Chief Justice of the Republic of South Africa in accordance with the dictates of the Constitution. We welcome you to this session of the JSC.
Thank you very much, Deputy President.
And we are tasked with the onerous duty and responsibility to interview you and the other candidates with a view to advising the President as to who we consider to be eminently suitable for the vacant position of the Chief Justice. Thank you.
Thank you.
You were born in 1962, and obviously by virtue of the position that you currently hold, you are a South African citizen.
Yes, I am.
You are married with 7 children.
Yes, Chair.
And you were appointed as a Justice of the Constitutional Court on 15 April 2013.
Although I took up office with effect from the 1st of August 2013.
That's your official date of appointment?
Yeah, the official date of assumption of office.
Thank you. And you have been a member of that court for 8 years and 10 months now.
Yes, Chair. No, this is the 5th month, I think.
Okay.
Yes.
8 years, 5 months. Thank you. Section 176(1) of the Constitution provides that, and I quote, "A constitutional court judge holds office for a non-renewable term of 12 years or until he or she attains the age of 70, whichever occurs first." Close quote. So you have some 3.5 years or so before you reach the end of your term at the Constitutional Court.
I will accept that. Must say, Kasach has raised an issue that I also used to raise, which is that maybe there is a possibility of saying I am entitled to the longer term, but I think, isn't there an amendment to the Constitution that refers to the term being determined by an Act of Parliament? Because I think in terms of the Act, there is then a reference to 12 and 15 years. The 12 years being in respect of judges, or judges appointed to the Constitutional Court having had the experience of at least 3 years, and then people without that experience being entitled to be at the Constitutional Court for 15 years. I might be mistaken, but that's my latest understanding. And it is on that basis then that there was the possible interpretation that because I was appointed directly from my practice as an advocate, my term could possibly be the 15 years. But on closer look, the possibility is that, and at a textual level, the possibility is that it should be the 12-year period, or 12-year term in my case, because I think the wording in a sense is neutral. A judge for 3 years. I had been a judge for 5 years before, and then I resigned around May of 2001. So short point, I guess after that long explanation, short point, maybe I should just say, I'm willing to accept that it's 3 years, 6 months thereabout.
Thank you, Justice Madlanga. And when were you called to the bar, and for how long did you remain as a practicing advocate?
1991, after serving the then 6-month pupillage, I started in Tata at the bar in July of 1991. I was not long at all at the bar. I was called to act at the High Court in Tata in 1996, and then with effect from the 1st of September 1996 still, I was appointed permanently to that court.
Thank you. And apart from your practice, were you involved in any community work or took membership of any of the lawyers' organizations?
I've been a member of virtually all, leaving aside the organized bar, or so-called organized bar. I was first a member of the BLA, and then I switched over to NADEL, and I was a member of NADEL for the longest time, and I was also a member of Advocates for Transformation, and I even joined this august body on the ticket of Advocates for Transformation, but of course under the umbrella of the General Council of the Bar.
Thank you. Have you delivered any papers at various universities, both in
Yes.
South Africa and abroad?
South Africa, in South Africa, what I have done is to offer my services to lecture law students, and offering my services for free. I contacted, when I was on long leave in 2018, second half of 2018, I contacted Fort Hare University and Walter Sisulu University, and made an offer to both of them to go and lecture there, and both universities accepted, appointed me as a visiting professor, and I lectured at Walter Sisulu University, and thereafter went to Fort Hare. Yes, I have delivered papers at universities in the USA, but outside of universities, I have delivered papers, like, for example, maybe more what, it was a paper which I even converted to an article at a judge's seminar, one of these seminars for judicial education, and that one was, you would probably have seen the GCB comment touches on it. In fact, they deal with it quite extensively, and at paragraph 8.6, they even quote copiously from that. And the title of that was a feminist perspective in what, I forget my own title now, but it was on a feminist approach to the adjudicative process. That's what the substance was.
Thank you. Have you received any awards from lawyers' organizations or other bodies here or abroad?
No.
Before you were permanently appointed to the Constitutional Court, you had occasion to act there. When was that?
This was at the second half of 2000 and the first half of 2001. So it was a total of 4 terms, which in court terms would have amounted to a year.
And apart from the exponential increase in the workload of the Constitutional Court, have there been any major changes to speak of in relation to the practices and conventions that had been in place at the Concord 2000, 2001, and when you were permanently appointed as a member of that court in 2013?
Two that readily come to mind are, I do not remember, but I might be wrong. I do not remember that we did duty. I think the president, and this was before the Chief Justiceship was transferred from the Supreme Court of Appeal to the Constitutional Court. I think the president, President Chaskalson, basically did duty and would make the initial recommendations on what we should do with a new application. Do we set it down? Do we dismiss outright? Do we call for written submissions by way of directions? And all those sort of, and then we would come in at that stage. And as you have acted at the Constitutional Court, you know that is no longer how we handle new applications. Everybody, with the exception of the Chief Justice, does duty. Then another one that I remember readily is, I'm sorry, that we would go to conference to discuss how we saw a case immediately after argument. Again, as you are aware from your acting state at the Constitutional Court, you know that that is no longer a case, and that what we do now, the allocated scribe will, or has 7 days within which to prepare a post-hearing note, which is circulated to all colleagues, and colleagues must in turn comment on it within 7 days. Those are the two that I remember off the top of my head. There may well be others I've forgotten now, if there are.
Thank you. Justice Madlanga, I do not propose to take you through your judgment because I believe that your record speaks for itself, unless, of course, you would want to dispute that statement.
Let me take the credit, President. Thank you, Deputy President. Thank you.
Section 176(3) of the Constitution provides that the salaries, allowances, and benefits of judges may not be reduced. And there is a sentiment out there that if you do not raise the salary of judges incrementally, given the ravages of inflation, this is in effect tantamount to reducing their salaries in breach of Section 176(3), thereby in effect impinging on their independence. Do you have any thoughts on that topic that you can share with the Commission?
It is not a subject that I have applied my mind to. And I would imagine that as lawyers, my colleagues would have applied their minds thoroughly to it and come up with concrete arguments before I take a particular view. Outside of just the statement you have put to me, I would prefer to first have sight of and assimilate the arguments on which this view is premised. So I prefer rather not to go either that way or the other way before I have actually seen concrete arguments. But I'm willing to accept that colleagues have a basis for saying so. Otherwise, I doubt that they would just make that point.
I want to put a proposition to you that if the salaries of judges are not competitive, the judiciary is unlikely to attract the best amongst the lawyers to the bench. I'm not suggesting that the salaries of judges should be, in parity with those that senior counsel command in private practice.
I will not argue against that at all. But now you've added the rider right at the end, because what you've cut across with that rider is exactly what I wanted to use to agree with the point that you were making. I wanted to say the fees that are charged now, based on what I hear, are quite high. I hear that counsel can make even 50,000 a day, 60,000 a day, 70,000 a day, and even more, 7,000, 5,000, and so on an hour. But you put in the rider that that's not what you are talking about.
Thank you. Justice Madlanga, I do not wish to take up much time with you because all of the other members of the commission have questions to put to you, but there are topical issues that are already in the public domain, some of which I would like to put to you and then invite you to tell us what you think of them, if anything should be done about those. I'll give them to you all at the same time, if you could take a note of them. The Constitutional Court has been under attack lately from certain quarters about a host of things. One, the extraordinary long delays in rendering judgments, the quality of the judgments, and some of the criticism has not been charitable. Namely, in one instance, the person who was critiquing the judgment said that it is a prattle of nonsense. Some judgments are replete with incoherence and reasoning is all over the place. The other one is the strong language used in the judgments, either the main judgment or dissent or both, which is viewed as being abrasive or combative, which is seen as reflecting adversely on the image of the court. Perhaps I should just pause there to afford you the opportunity to respond.
I have actually prepared quite a long note on the delays. It would take a very long time for me to go through it, and that would probably test the patience of commissioners. But maybe let me just try to summarize what I see or understand to be the cause for delays. Let me just quickly go to some statistics that I have here, Chair. May the commissioners please bear with me.
Please take your time,
Yes.
Justice Madlanga.
Thank you. I'll rattle them off the top of my head. I can't find them now. But for a long time, from about 2009, and 2009 is a signpost because that is a time when the working procedures of the Constitutional Court were last revised. Around that time, and even beyond, up to 2013, new applications averaged around 100, just over 100 in total. And then came, with effect from the 23rd of August 2013, a constitutional amendment which afforded the Constitutional Court what we loosely call general jurisdiction, the effect of which was that the Constitutional Court no longer adjudicates only constitutional matters. As you know, Chair, it now adjudicates even matters involving arguable points of law of general public importance. It was to be expected that there would be a sudden deluge of applications. Indeed, there was an increase in 2013 already, that is the year of the amendment. But that year, the increase was modest, and it is understandable why. It's because we were already in August and not much of the year was left still to run. And then so I think the figure there was still in the hundreds, but upper hundreds. And then in 2014, the figure shot up well over 200. And then since 2015 to today, new applications have been averaging well over 300. Last year, they were 394. So in no time, we may get more than 400 new applications. To somebody sitting here, that may sound like a very small figure. Based on how the Constitutional Court works, that is actually a very large figure. And this is a function of the Constitution. How? Because how the Constitution is structured, or how it provides, the Constitutional Court, unlike the Supreme Court of Appeal, for example, cannot decide cases in panels. At the Supreme Court of Appeal, 2 judges can dispose of an application for leave to appeal without the colleagues even having sight of that application. At the Constitutional Court, because the court is constitutionally defined to be 11 justices subject to a quorum of 8, all 11 justices, or at least 8, must participate in each and every decision that the Constitutional Court takes. That means each and every one of us must bring her or his mind to bear to each one of the 393 applications that we received last year. That is the one thing. And then added to that is how we used to work, or how we used to do new applications. As you know from your time there, Chair, we used to have the duty week system. In terms of that duty week system, 2 judges would be on duty for a whole week. Those 2 judges would be the first port of call for new applications. If 4 applications come in during that week, they split them in the middle, or if an odd number comes in, the judge who took the first matter will get more. So we'll get the 5th matter as a 3rd matter for her or him. A disadvantage in this, in fact, at least 2 disadvantages. The first was that the weeks were hardly ever the same. In one week, there could, and in fact, there were far more applications than the following week. Let me be anecdotal and just give an example of one very unfortunate colleague, Justice Mhlanhla. In 1 week, I forget who she was paired with on both weeks. I'm going to touch on the 2nd week. She and her duty partner got something like 22 or so applications in 1 week. Then other colleagues came in a few weeks, and then when after a few weeks she was back on duty again, she got another 20-something applications. Again, I've forgotten who her duty colleague was. Now, the problem with the duty system was that there would be a deluge of applications all coming in at the same time that had the effect of bogging you down, slowing you down in being able to deal with them expeditiously. That then had a knock-on effect on everything else that you do. In the same way that I've explained, about the decisions that we have to take, and my focus, of course, in this context being on new applications with judgments as well. I earlier mentioned the post-hearing note that I said you are aware of. A scribing chamber will circulate a post-hearing note on a judgment. The post-hearing note, commissioners, if I must explain, being just a summary by the allocated scribe of the approach that the scribe proposes to take in a particular manner, giving reasons why. And as I said, colleagues must comment on that. So you have this deluge of, and then down the line also, after 14 days from the deadline for comments, that colleague then must circulate a draft judgment. So you have this deluge of applications. The time has not stopped for you to have to comment on other colleagues' post-hearing notes. And remember, there are 11 of us. You must comment on 11 post-hearing notes that are in circulation. And once drafts come in, draft judgments, you must comment on 10, by the way, because you have your own. You must comment on 10 draft judgments. And as I try to emphasize, you have this deluge of applications that has come in at the same time. That had a very negative impact on how we work. Did we throw our hands up in a Pilatian manner like Pontius Pilate did? No, we did not. Last year, in the second half of last year, a decision was taken by conference on what we should do about this. Maybe I should just add that the knock-on effect of all this was that in the end, judgments would be delayed because come the deadlines, because there are set deadlines in the working procedures, 7 days for a post-hearing note, 14 or 7 for comments on the post-hearing note, 14 days for the first draft, and then 14 days for the next draft, and it's always 7 days, 7 days for comments on whatever. Now, the effect of that would be, come the deadline, colleagues would ask for extensions, and that delayed the process. But as I say, we did not throw our hands up in the air. In the second half of last year, a decision was taken by conference, I'm sorry, or that we should revise our working procedures. I was in the fortunate position of being one of the colleagues, the 2 colleagues chosen to perform that task. And the other justice that I was paired with was acting Justice Daya Pillay. We have produced a document, and I must acknowledge the assistance that we got from our law clerks. In particular, I want to single out Sarah Goldman, who did a wonderful job on that. On what we came up with, we have not circulated the full document to colleagues. When Justice Pillay left a couple of weeks back, we were still in the process of finalizing the rest of the document. I hope to have it circulated maybe during the course of February. But here's something that I consider quite important, which we did. One of the suggestions that we have put forward in the working documents is to do away with the duty week system. And because we identified the duty week system to be at the center of our problems, we took our suggestion, which was suggesting to colleagues that we do away with the duty week system. We took it away from the rest of the document. We presented it to colleagues, and fortunately, colleagues accepted it, and we implemented it immediately. It took effect on 5 December 2021. How does this cycle system work? We list all the names of the judges on there, with the exception of the acting Chief Justice. And the first case that comes in is taken by the judge who is first on the list, and then the second one by the second judge, and so on until you get to the end. The effect of that is, 1, there is even distribution of new applications, and 2, there isn't the problem of a deluge of applications all coming in at the same time, with the result of bogging you down. From the 5th of December to this day, I have received only 3 applications under the cycle system. One was now a couple of weeks now in January. I have already finalized and circulated decisions on the first 2 that I received. That is a function of the very fact that you do not have that sudden deluge that just pins you down, as it were. Now, this is not just about me. It is not just about me. I have spoken to a few of my colleagues and asked them how they find the cycle system. They too say that it is quite a pleasure. It is a great improvement on how we are able today to finalize new applications.
Justice Madlanga,
Yes.
I have to interrupt you there.
Yeah.
The long and short of what you have just told the members of the commission is that you have identified some of the factors which are contributing, to the excessive delays that are experienced at the Constitutional Court, and that you are in the process of putting measures in place to address or deal with those challenges.
Yes. And yeah, it's now it's freeing up a lot of time. We are going to be able to even attend much quicker to everything else that we have to. The comments on post-hearing notes, comments on draft judgments, and so on. So much that in the proposals, which I would, to the extent that there was something about a vision here, I would put that in as my vision. Of course, with my partner, Judge Diapile. One
we
proposal.
Perhaps deal with that?
Because your question was about judgments, let me perhaps just zoom in on that now.
Yes.
So with the freeing up of time, I believe that we are going to be able to deliver judgments much quicker. I have a firm belief on that. The proposal has something concrete, but we are yet to put it to colleagues. And that proposal is that we must deliver judgments. People will probably, commissioners and other people listening will perhaps still feel that it's a long time. But we are putting down a proposal of 5 or 6 months for the delivery of judgments. We have done a comparison, and this compares quite favorably with what happens in other foreign jurisdictions. I would say the United Kingdom is an outlier because there they deliver judgments within a few weeks after argument. That's an outlier. Some of the other comparators are, in fact, most of them are, that is those that we looked at. I do not know about others, but those that we looked at, most of them are 6 months, and I'm talking about apex courts of those other jurisdictions. So 5 or 6 months, looking at what pertains internationally, I do not think would be that bad, as long as we do the best that we can to stick to that. And I believe that with the time having been freed up, it should be attainable.
Thank you, Justice Madlanga. Section 174(2) of the Constitution provides that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. And yet, looking at the composition of the Constitutional Court, there's no white judge, be it male or female, and the last appointment of a white judge to the Constitutional Court was in 2009. So for 12 years, no white person has been appointed to the Constitutional Court, despite the fact that during that period there has been about 7 vacancies. Would you want to weigh in?
I would throw that one back at this august body, Mr. Chair. more seriously, I think there is a point to be made about all of us as South Africans being made to feel that we all belong. So I do not, speaking for myself, think that it would, maybe let me not put this in the negative. I think it would send a good signal if there could be an appointment from that sector of our community. But let me say this. Section 1742 is not so categorical as to say, this is it. If there is X percentage of white people, then that is the representation that they should get at the various levels of the court. If there is that percentage of another grouping, even including outside of racial groupings, other possible groupings as well, LGBTQ+, and so on. That is not what, the Constitution is not categorical in the sense that you just must have that kind of composition, but it is giving an indication that there must be an attempt at attaining that. And as I say, I think it would send a positive image to try as much as possible to go in that sort of direction. But as I say, not to the extent of saying that it just has to be done. I would not go that far.
Justice Madlanga, we have now reached a stage where I must afford you half an hour to tell the members of this commission and the nation at large how you see the role of the Chief Justice in a constitutional democracy, and also share with us your vision of a functional, efficient, accountable, and independent judiciary in South Africa. Thank you.
Thank you, Chair. I must say you've removed a chunk from what I had on here as part of my vision, which was the idea of dealing with what I consider to be the largest elephant in the room, which is what pertains at the Constitutional Court itself. So I was going to share there what I see as my vision. Well, I believe that I have already done so. What I also would have emphasized in the context of what I've already debated in the context of new applications, what I would have emphasized was the fact that with the delays on which I think we now have a solution, perhaps there could quite easily have been an impression out there that maybe we do not work hard enough. I had intended to dispel any such possible perception. I just wanted, at a factual level, to make the point that we actually do work hard, in fact, very hard. And I even wanted, anecdotally, to share with the commissioners that I was working on Christmas Day. I delivered a judgment on the 31st of December 2021. Those are the sort of times when people are having fun, when people are with their families, sharing time, resting. And again, I want to emphasize, this is not just about me. Even if I will not know for a fact when my colleagues were working around this time, but I know they were actually working. And I say this because around the festive season, there was a point when my inbox, my email inbox, had well over 600 unopened emails from all my colleagues. So the point I would have made would be that whatever the reasons, and I've tried to zoom in on them, and I have shared my vision on addressing them, and we have immediately effected part of it. May I also, just again focusing on the Constitutional Court, say that one aspect that I feel conduces to a lot of injustice and which needs to be addressed is the problem of seating even numbers. I touched earlier on the fact that the Constitution provides that the quorum is a minimum of 8 judges. I remember when I acted at the Constitutional Court asking one of the colleagues, I forget who it was, why it is that the Constitution chose an even number for the quorum. And the colleague said it was felt that 9 was too high and that 7 was too low. I'm not sure that that is a good enough reason. Because the point is, in fact, when I asked the question, I was not aware that the Constitutional Court had ever been evenly split, not at that time. But the commissioners sitting here, I'm sure you are aware that in recent times, there have been quite a few cases in which we have been evenly tied. That is a very unfortunate outcome for litigants. Because when you appeal, it is not just appealing for the sake of appeal, you are actually exercising a constitutional right under the rubric of a fair hearing, fair trial. You are also entitled to the right of appeal. And now, here's the injustice. Once we are evenly tied, the effect of that is that the judgment appealed against stands. So it's as good as if you never appealed at all. So it must be clear to everybody listening here that that is an injustice. I want to approach the minister, if appointed, I want to approach the minister to move that there be a constitutional amendment and that we do away with the quorum of 8, and that we decide, it may be 7, it may be 9, I'm not that much concerned what it should be, but preferably 9, because 7, if we are a court of 11 justices, yeah, maybe 7 would indeed be too low. But I'm quite comfortable with 9. But the even number just does not make sense for me. Then what adds to the problem is that now we ourselves, outside of that minimum of 8 in terms of the Constitution, we ourselves do sit 10. And sitting 10, we have had 5-5 splits. Maybe that too would have to be addressed But unlike the quorum, maybe it does not necessarily need a constitutional amendment. It's something that could be dealt with even in an ordinary act of parliament. Or we ourselves could internally find a practical way of dealing with this. For example, in the late 90s, I also acted at the Supreme Court of Appeal. I remember preparing very hard for my very first hearing at the Supreme Court of Appeal. And then 2 or so days before the hearing, Chief Justice Ismail Mohammed approached me and said his deputy had taken ill and was therefore not available to sit, and he asked me not to sit. So that we were a panel of 5, so that they could then sit a panel of 3. Reluctantly, I had to say yes to that. So because exactly, or exactly because of the fact that at the SCA they have devised a practical way where there is no statutory or even constitutional bar or problem as such, I think we too at a practical level could just do that. But I guess, the issue would be who do you take out and why out of 10 colleagues. But maybe we could just find a practical way, maybe rotating or whatever else. But perhaps the best would be an amendment to, or rather, a statutory amendment at whatever level. It might be an act of parliament, or it might even be a constitution, the constitution. And I would, of course, with regard to the quorum, which requires constitutional amendment, request those members of parliament who sit here to support the move and also push for that constitutional amendment. Then also there is the question of administrative functions for a Chief Justice. I must confess, Chair, that sitting outside of the leadership of the court, I cannot claim to be aware of the exact functions of, that is, administrative functions of the Chief Justice, outside of those that are constitutional or even statutory, for example, in terms of the Judicial Service Commission Act. Outside of those, I cannot claim to know what they are. But if appointed, I propose immediately to engage with other heads of court and the Secretary General of the department responsible for court administration, which is called the Office of the Chief Justice. The idea will be to establish the extent of the Chief Justice's involvement in administrative functions. In striking a balance between administrative and judicial functions, we must pay particular attention to the fact that, first and foremost, a Chief Justice is a judge, a jurist. As a judge and constitutionally ordained head of the judiciary, I believe that a Chief Justice must lead the judiciary from the front in terms of the creation of the country's worthy and lasting jurisprudence. Depending on the nature of administrative functions that the Chief Justice currently performs, one may have to look closely at them and see which ones, if any, one may have to be relieved of. Of course, there are those functions that are prescribed by the Constitution and other laws like the Judicial Service Commission Act and the Superior Courts Act. The Chief Justice must and has no choice perform those. I should not be misunderstood. I am not saying that outside of those, the Chief Justice must perform no other administrative functions. What I am saying is that a Chief Justice must not be a super Secretary General or a super Director General. The Office of the Chief Justice, which is the department responsible for the administration of the judiciary, is headed by a Secretary General, and my understanding is that Mayor Sijo Singh has been performing a sterling job in that regard. And I understand that for the past 3 or 4 years, the OCJ has had clean audits. All the more reason that a Chief Justice should not be a super Secretary General. But this does not mean that the Chief Justice must be in the dark as to what is happening with regard to administration. There should be those necessary interactions between the Chief Justice and the Secretary General. In the main, a Chief Justice must be a trendsetter in the creation of our jurisprudence. That, for me, is the core function of a Chief Justice. That does not equate to the Chief Justice being in the dark. I've just made that point. A balance must be struck. Moving on, for a while now, I have heard the idea that some court rules are no longer suited to today's circumstances. If appointed, I will sit down and, with a thorough tooth comb, identify those rules and bring them to the attention of the Rules Board. Of course, this is not something that I can and will do alone. Because I'm talking about rules in general, there are the uniform rules, there are even practice directives and so on. So I would definitely have to involve other heads of courts in that process. I think of the example of rules both in the magistrates' courts and superior courts that require parties to have an address for service of all process on them within a specified limited radius from the seat of the court. Take the example of a poor, self-representing person who lives in, and I'm addressing your province, Judge President Tlaletsi. Take the example of a poor, self-representing person, and I'm taking the Northern Cape because it has the vastest land mass area in South Africa. At least that's my belief. Maybe Advocate Madonsela's province who compares fairly, but I think the Northern Cape has the most vast land area. Take the example of a poor, self-representing person who lives in Springbok in the Northern Cape and knows nobody in Kimberley, where the seat of the High Court is. Bear in mind that the distance between Springbok and Kimberley is some 780 kilometers. Where and how will that poor person find an address within the stipulated radius? Also take Constitutional Court Rule 1.3 that requires the filing of 25 copies of all documents, which include records that may be quite lengthy and very expensive to produce. What makes matters worse is that Rule 20, Sub-Rule 2H, says the lodging of electronic copies of documents does not relieve the party concerned from the obligation to lodge 25 hard copies. I've just taken out 2, but when one sits down, one would be able to come up with many. But the point I want to highlight here is that rules of this nature are at odds with the right of access to court. But I must say that perhaps this, and I'll qualify it shortly, this may be ameliorated to an extent by the rollout countrywide of the court online system. The court online system was introduced by the heads of court at the instance of Chief Justice Mogoeng after he had observed its beneficial use elsewhere in the world. Heads of court decided to first run a pilot phase, and Gauteng was chosen for that purpose. This system comprises two components, which are what is called customer relationship management dynamics, and the short that they use for that, and I assure commissioners it has nothing to do with the president of the country. They call it the CRM dynamics. The first component concerns what under the present system would be an interface with the registrar's offices, the lodgement of papers, giving of case numbers, and so on. CRM now makes it possible for all this to be done online. Now, the second component, case lines, is at the other end of the process. That is what actually happens in court, the documents that the judges will have before them, and then what will also go into case lines as the hearing itself unfolds. And my understanding is that the pilot implementation of this at Gauteng took place under circumstances that were not the model circumstances that one would have wanted it to the system to unfold. And this is how this happened. Microsoft was engaged to set up the system, and Microsoft said, with case lines that you can buy off the shelf. It's a system that's out there, readily available. But the CRM dynamics has to be custom made, developed for a particular client. And that has just been finalized on my understanding and will again be run as part of the pilot project in Gauteng. But case lines, or rather, yes, case lines was implemented immediately after a license had been purchased. Now, the problems I was alluding to were, because the two systems interface, you receive the documents, everything on CRM dynamics, then it has to interface with case lines. There had to be, because you don't have the CRM dynamics, there had to be a lot of scanning and so on at huge expense for purposes of uploading everything onto case lines. But Gauteng managed to get on top of that, and they got it running. But now that CRM dynamics is ready, the two will interface, and again the two will still run as a pilot in Gauteng, but for a short time now, and there will be a rollout countrywide. But my understanding is that this will be a phased project, not all courts at the same time. Phased because you need the support system to see whether the project is running smoothly. So an incoming Chief Justice will have to be on top of things, see how the process is running, make sure, or try to make sure as far as possible, that the phased implementation is not delayed more than it should. I said there was something I was going to come back to shortly. So when Court Online is fully operational, the idea is to be paperless. Of course, this will create problems of its own. A large number of the South African population either does not have access to computers or is computer illiterate. So the question remains as to how that section of the population will be serviced. My understanding is that there will be kiosks at high courts to assist people who cannot upload documents onto the system. There will also be a call center that will assist people over the phone. But commissioners will immediately see that if you are computer illiterate, there is nothing that somebody at the other end of a telephone, there's nothing they can do to help you. That takes us back to the self-representing Springbok litigant who must travel to Kimberley to access the kiosks. If the litigant is computer illiterate, not even an internet cafe close to home will be of assistance. All of this is a function of the situation in which South Africans find themselves, deprived by the educational system, deprived by poverty. So yes, the system is good. Yes, the system does have advantages, but it will not be able to, at least not immediately, and not even in the medium-term period, it will not be able to address these problems, which are a function of disadvantage and deprivation. As I say, Court Online is definitely a welcome innovation, but in introducing it, it must be run in tandem with a system that will cater for the interests of those who cannot access it. This is something a new Chief Justice will have to look into quite closely. But as I say, there are certainly advantages, and indeed comments from users have been quite positive. The judiciary is not only about superior courts. The magistracy is an integral part of it. I am aware that there are certain issues that the magistracy wants to be addressed. As I understand, at least two issues that the magistracy is concerned about are its transfer from the Department of Justice to the Minister, you will forgive me, I never know when to call it Department of Justice and Constitutional Development or Department of Justice and Correctional Services. And I'm saying this because I think I've seen when reference is made to your one deputy that the CD is added, whereas when reference is to you, the CD is not there. Anyway, if appointed, I will engage the magistracy to listen to its concerns and see what needs to be done. Of course, since the magistracy is under a department headed by the minister will have to be engaged. I do understand that the question of the transfer of the magistracy has been on the table for quite a long time. if appointed, I would sit down with the minister and try to understand what the issues are, what the holdup is, whether even the very idea of a transfer is accepted or not. If not, also ask for the reasons as to why not. But to me, sitting here, I think it makes a lot of sense that the magistracy and judges of superior courts do have to be under the same umbrella. We are all judicial officers. Because I had dwelt or delved quite a lot on the issue I dealt with when you were questioning me, Chair, I just noted other points as cryptic bullet points because I had timed my address. I had done a speech converter, and by the time I got to the point where I am now, if I had not cut out the point about delays at the Constitutional Court and my vision for addressing that, I would not have been able to reach these bullet points. But now that I think I still have a bit of time, let me deal with them. But as I say, they are rather in the form of cryptic notes. I want to suggest that, to me, there is something that is quite important and which I consider to go to the dignity of those that we interact with as the judiciary. And this is something that is already highlighted, or rather, this is something that is highlighted in the article or address that I referred you to earlier, commissioners. There is what I wrote at a seminar about a feminist approach to the adjudicative process. And it also goes not only to that, but also to a wider subject of sexuality, sensitivity of courts. Let me just quote what the comments of the GCB have quoted from what I wrote. They say the candidate, and this is at paragraph 8.6 of the GCB comments on me. They say the candidate appears committed to ensuring that the Constitutional Court's jurisprudence continues to contribute towards the attainment of equality by women. And then they quote me where I previously said, the end point we should all strive for is to dismantle the patriarchal, sexist, and misogynistic elements underlying our judgments. We can reach that end point if, in our judgment writing, we consciously embrace the truism that women are equal to men, and that several phenomena affect women in a myriad of ways which are either not discernible or not readily discernible to men. These are issues that are quite important to me. These are issues that go to the dignity of people. In the full article, I deal quite at length with a number of cases that display sexist, patriarchal, and misogynistic attitudes of men towards women who appear before our courts as witnesses, in particular those women, and I cite quite a number of cases, who are rape survivors. We need to be very careful, and if appointed as a Chief Justice, as I said, this was a paper I delivered at a seminar for judicial education. If I were, and this was just a once-off, but if I were to be appointed, this is something that I would truly, truly take up more seriously and very energetically try to sell to all my colleagues. Then, on the related aspect, sensitivity on questions of sexuality, there is something that we take very for granted, and yet it goes to the core of the rights, interests, and dignity of LGBTQ plus people. When I meet counsel, which I did for almost half a year last year, as a presider, because for I think maybe close to 90% or more than 90% of the time, I presided at all constitutional court hearings. When I see a man, or at least somebody who appears to be or looks like a man, and I'm sure most of my colleagues do the same, I will take that person to be a man, and I will say, Mr. So-and-so. But I have learned that this is a sensitive issue to the LGBTQ plus community. And we need to have a particular sensitivity to this. And maybe it is time that the judiciary considered inquiring what a practitioner's or even a litigant's or a witness's preferred title, or even no title at all, who knows, is. What the preferred, instead of just because the person has a beard, then you say, yes, Mr. So-and-so. We need to be sensitive to those if we are to give true content to our Constitution and to the dignity that it so seriously espouses. Then there are difficulties with regard to physically accessing courts, and high costs, logistical difficulties, especially for those in rural areas. But even for those living just outside of cities, for whom travel to the central hubs where courts are is difficult and expensive. A Chief Justice coming in, because this again is an access to court issue. And because in this context I even refer to people living close to the city, but for whom it is still quite expensive to travel to courts. I know South Africa right now has serious financial constraints, but these are aspects that should exercise our minds. These are aspects, because access to court is not something that should be taken lightly. These are some things or issues that we should try to apply our minds to and see if, for example, instead of somebody who is poor and the only money that they have is to buy a loaf of bread and to be able to have food together with her or his grandchildren. They do not, somebody like that does not have the luxury of taking a taxi from, for example, Soweto to come to town in Johannesburg for a hearing. Is it not possible for the court in Protea, Soweto, to have some screen for that person to go to, listen to the proceedings at Protea instead of coming to downtown Johannesburg? These are issues that some of us may see as insignificant, but the fare to come from Soweto to Johannesburg, and I will emphasize this, may mean to somebody who is poor the difference between going to bed on an empty stomach or having food, even if it's a loaf of bread on your table. Now that we have seen that online hearings work smoothly, we may have to consider. In fact, that would actually be, how these work. It could actually be a springboard for us to do what I have just referred to. People watch on YouTube. Something like that could be taken to the Soweto court, to Protea. Of course, I'm just singling Soweto as an example. It could be taken to some community hall in some area, and then people, or maybe YouTube wouldn't quite work, but at least that is an indicator that the technology is there. I would also move for an amendment of the Judicial Service Commission Act with regard to the different levels at which the Chief Justice participates at Judicial Commission processes. The Chief Justice chairs the full JSC, but the Chief Justice also participates at the lower, if I may use that term, the lower processes of disciplining judges. And then as a practical measure, and this is something that we did when I was part of this body for 2 years, and at that time Chief Justice Nobo was the Chief Justice. Around this issue, what we decided the Chief Justice should do was rather to delegate at that level and then to be able to chair the JSC. Because once the Chief Justice participates at that level, then the Chief Justice cannot again participate at the full Judicial Service Commission. But I think rather than coming up with a practical solution, I think there needs to be specific provision on how this should be handled at the level of the Act itself. And then also, what if appointed, I would attempt to sell is more use of Rule 41A on mediation. There are times when I think mediation would come in quite handy. Those of us who are lawyers here will have had the experience of how strongly litigants feel about their cases. And unfortunately, sometimes even we as lawyers would side firmly with our clients and make no attempt to make them see reason. If my client is fighting, I am also in that fighting mood, and unfortunately, the litigant on that other side and my opponent are in that same mood. I think the idea of a mediator, not the judge or the magistrate a mediator who is going to engage the parties and coming in neutral, that would, I believe, assist our judicial system in the sense that we have a lot of cases before the courts, hence the backlogs that we have. If mediation were to work and get rid of cases that ought not to have been litigated at all, or at the very least, cases that are settleable, it would relieve the court of a burden that will then enable it, that is the court system, not just a single court, the court system, then enable it to deal with cases that it indeed ought to deal with. And there is an article, and I would, if appointed, just revisit it and look at the concrete suggestions made in it. There is an article written by one of the deputy judges, president of Gauteng, Deputy Judge President Roland Sutherland, in which he is advocating for more use of the mediation system. What I also want to have a closer look at is on case flow management, an innovation that I think is has borne fruit, and it is an innovation that was brought in by Chief Justice Mogoeng. Just one aspect that I think I want to look at and see if judges president would find it acceptable and indeed workable is whether, because I have, for example, heard sight of maybe one or two of the practices on case flow management, but what I have found is that it does not provide for the management of a case as it flows through the process by one judge. I understand maybe in the smaller divisions, I do not know, maybe it may not be all that practical, I do not know. But it is an idea that I would want to bounce off the judge's president. Because if I do one little bit in the process of managing a case and then I'm off and a colleague comes in, that colleague will not have a clear idea of where I was going with a case when I took a, yes, maybe sometimes it may be clear where I'm going, but if I do this and the case comes to me next time, I know exactly why I did what I did earlier, and from this point on, I know what I want. So I think it would add something to a process that I think is already good. So I put it no higher than saying that I would put it as a suggestion to judges president, see if they find it acceptable and workable. And then another aspect which is close to my heart is the question of arbitrations of commercial matters. There is a perception that wealthy South Africans, for whom, or in respect of whom, for the most part, you can read white, are not comfortable with having their cases heard or adjudicated upon by black judges. And the perception is that they do not have confidence in them. So, which is why those matters are taken out of the judicial system or our judicial system and brought before private arbitration. I would want to get to the bottom of that. I would want to, one, look at that very perception, and two, look at what needs to be done from our perspective as the judiciary. Is there, or what shortcomings are there? Yes, I do know that there are delays. Yes, I do know, like it takes a long time for cases to come to the stage of a hearing and so on. But I would want to just have a look at what we would be able to do to address whatever problems there are within our system. But of course, I think to a large extent, case flow management has eaten into the delays that we have been having on matters coming to court for hearing. So at least there has been an improvement in that regard. And then I would also want to say that nobody has the monopoly of knowledge, the monopoly of wisdom, the monopoly of ideas, intellect, etc. So I would approach, and for me this would be the first port of call, I would approach all levels of the judiciary, and this is something I would do immediately. I would meet the President of the Supreme Court of Appeal, I would meet the judges president, I would meet the presidents of the regional courts, I would meet the cluster heads of the magistracy at district level to get an idea of what the problems are from their perspective. And I believe that this would help inform the approach that I would take with regard to improving our judicial system. And of course, I must acknowledge the fact that an incoming Chief Justice would not be coming in on a clean slate. The Chief Justices before have done a lot of sterling work, and they set up templates. So one would, I've mentioned, for example, the case flow management. I've mentioned the introduction of Court Online, which has the two aspects that I referred to, and the introduction of the Code of Conduct for judicial officers. So a Chief Justice coming in would take in from that point and take the process forward. Those are my, if I was in court, I would say submissions, Deputy President.
Thank you, Justice Madlanga. In fact, you exceeded your 30 minutes by almost 20 minutes.
You?
So I was somewhat generous to afford you the opportunity to wrap up.
Thank you very much, Chair. Thank you, Deputy President.
I think this would be the convenient stage to take the mid-morning adjournment. According to our schedule, it should be 20 minutes. I make it 11:45 now. Shall we then resume at 12:05?
Thank you, Chair.
Fellow commissioners, shall we resume with the business of our meeting? Thank you, Justice Madlanga, for your presentation.
Thank you, Chair.
At this juncture, I shall take a pause and allow the members of the commission to put such questions as they might have for you. And fellow commissioners, in accordance with the traditions of the commission, will those who wish to speak alert me, and I will allow them to do so in the order in which indication is made to me. Thank you, Honorable Minister.
Chair, may I just say that to the vision, there is no way that one cannot add the perennial problem of perennial and systemic problem of delays in the finalization of both criminal and civil matters. That is a matter that I if appointed, I would also want to look at. I will not substantiate on that. Thank you.
Thank you, Justice Madlanga. Okay. Okay. No. Commissioner Malema, did you have your hand up? Okay, thank you. Commissioner Nyambi, did you have your, okay, thank you. Thank you. Advocate Kane, have noted you. And you too, Commissioner Tsepe. I've noted you too, Commissioner Malota Tlepo. Commissioner Shabangu, I've noted you. Ndawe. Professor Slema. Commissioner Casey. Okay. Okay, Commissioner. I've got you already, Commissioner Dodov. And you, Commissioner. Okay. Commissioner Lucas.
Deputy President, I have my hand up virtually. It's Clemens Breitenbach.
Thank you, Commissioner Breitenbach.
Commissioner Barnes' hand is also up.
And Commissioner Barnett, I've noted you as well.
I would like to be noted as well.
Yeah.
Thank you. I've made note of all the members of the commission who have questions for Justice Madlanga. Honorable Minister.
Yeah. Thank you very much, Acting President of the Supreme Court of Appeal. And good morning, is it still morning? Afternoon, Justice Madlanga.
Good afternoon, Minister.
Thank you. My question relates to the separation of powers and the court administration model. What do you see as the role of the three arms of the state with regards to the separation of powers and in the development of the court administration model, with the examples of benchmarks that yourself as the judiciary might have done? And what do you think will be the role of the Chief Justice to ensure that this court administration model does materialize?
Minister, maybe because you preface your question with a broader question of separation of powers, I would say that constitutionally, all the various, or the three arms of state have carefully delineated powers. And in general, and I emphasize in general, each one of them must stay within its lane. Why do I say in general? I say in general because more than one judgment of the Constitutional Court, off the top of my head, I can think of the judgment in the matter of Heath. I think there was an earlier judgment which was penned by Justice Ackerman. I forget the name of that one. There may be one or two others. The Constitutional Court said that even though there is this separation, our model is such that you can never talk of 100% separation. There may be that area of confluence or area of a bit of mixing up. And how did this arise? In the context of the Heath matter, it arose with regard to the question whether a judge could head up the investigative unit, which at the time was even named after the judge, which it was called the Heath Special Investigative Unit. And the Constitutional Court said, no, that cannot happen. But in other contexts, like for instance, issues around the issuing of warrants of arrest, which in a way some might view as more executive than judicial functions. The court said, no, but because that requires the sort of application of the mind, which in a sense is the exercise of a judicial function, there allowance can be made for the judiciary to perform those sort of functions. But going back to the broader issue of the separation, and the last part of the question that you zoomed in on, for there to be a clear understanding of the separateness of the judiciary. There was a need, and I do subscribe to that idea, for the administrative support to the judiciary to be an entity that is identified with the judiciary, and that resulted in the creation of the Office of the Chief Justice, which is nothing other than a government department which services the judiciary. That, in my mind, does accord with the broad idea of this constitutional separation, and not only that, even the need for it to be seen to actually exist. Then, with regard to the participation of the Chief Justice in that landscape, I think I did, that is earlier, I did touch when I dealt with my vision with regard to the sort of Chief Justice that I would like to see, a Chief Justice who leads the judiciary in terms of setting up a worthy and lasting jurisprudence. I did touch on the fact that, in my view, a Chief Justice should not be a super secretary general. Those administrative functions that, for example, whilst the judiciary was under the Department of Justice, were performed by the Department of Justice under a Director General. Those functions must be performed by the Office of the Chief Justice under the directorship and headship of the Secretary General. That is terrain that the Chief Justice should not stray onto. And I might even mention that there will be certain administrative issues that we as judges sometimes approach the Office of the Chief Justice on, and not being aware of the nitty-gritty with regard to prescripts applicable to them. And the SG never wavers, and she just tells us that, Judge, the prescripts do not allow that. I respect that, and that is something, if appointed, that I will honor. But as I said earlier, I would want to know, and I think the SG does cooperate in this regard, I would want to know what is happening, what must I know, what must I be told. For example, because I would not want to see something that has been out there for a while and learn of it for the first time from the media.
Yeah, my second one relates to the matter you spoke about of case line and the modernization of the system. And I heard you speaking about the fact that it has only been done as a pilot in Gauteng. Has there been any efforts that you have been involved in with the Concord or in your role in the Judicial Institute to infuse modernization and digitization of the entire court administration system? And if not, what will be your role as a Chief Justice to ensure that this is harmonized for all judges, for all magistrates, and the entire processes of the judiciary?
We are now in the fortunate position that, as I indicated to you, Minister, the process is right at the tail end of the pilot project. Once the CRM dynamics comes in, is interfaced with case lines, and it is, again, for a very short time, the two interfacing piloted in Gauteng. My understanding is that within a few months thereafter, it is going to be rolled out initially to a few high courts, maybe up to about 5. That's my understanding. I may not be accurate on that information. And the question may then be, but why not to all high courts at the same time? My information is that you do not want to go to a whole lot at the same time because you want the support people who attend to the actual rollout in physical terms are of a limited number, and you want to be able to grapple with a lesser number. And then once it is in place in the 5 plus Gauteng, then you roll out to a few more until you are done with the High Court. With the explanation that I have been given, which is the reason why a phased rollout, I think I must accept that. I must settle with that. And then also, my understanding is that implementation is meant to be as soon as possible, perhaps to take part simultaneously with the first phase, that is at the Constitutional Court and Supreme Court of Appeal, to take place simultaneously or roughly simultaneously with the first rollout to some of the high courts. I must confess at this stage, Minister, that based on the information that I have, I am not aware of the intended processes with regard to rollout to the magistracy. But if appointed, and with the advantage of the system already being in existence, that is both the CRM and case lines, I will be on top of things with regard to how do we get this to all the courts in South Africa. That nitty-gritty is something that I believe one can easily be on top of.
Thank you, Judge President.
Thank you, Honorable Minister. JP Tlaletsi.
Thank you, Acting President, and good afternoon, Justice Madlanga.
Good afternoon.
We spend the whole year together, but you only meet for the first time physically today.
That's terrible.
It's terrible, yes.
Sad.
I think you've covered most of the issues that I wanted to raise, but for information on the case flow management model that is being used,
Yes.
it was envisaged that the allocation of cases to judges will enable them to go through with those specific cases up until they are trial ready, and that judge would not be the one to do the trial.
Okay.
In the divisions, not smaller, but with fewer judges,
Yes.
like Northern Cape, that system is how it's operating at the moment.
Okay.
And I can say it's a success.
Thank you. Then I'm happy that at least I had an idea of pushing for something that in fact the courts have actually thought of. So I was not completely off the rails. Thank you, Judge
Thank you.
President.
And then on the issue of the Super DG, I think, or Super SG, I think that's a very important aspect because there seems to be a lot of misinformation that the Chief Justice can do as he or she pleases and interfere.
Yes.
And obviously, the Public Service Commission, the Public Service Act does not apply to the Chief Justice and the Judiciary. So there are people who are officials who deal with that as the support structure to the Judiciary.
Thank you.
Then my next question is, have you considered the, informally, of course, conducted a skills audit of the Constitutional Court in particular and the Judiciary, particularly the superior courts in general? where we could be lacking and how we could improve?
Formal skills audit definitely.
Informally,
not.
that's what I'm saying.
I'm so sorry. Even informally, I must confess that is not something that I have done. But maybe what I could say off the top of my head and based on my experience as a legal practitioner, and which of course fits into the judiciary, is that maybe at the initial stages when a colleague comes to the bench, and let me be specific and say black, and I could even go further and say women. At the initial stages of coming to the bench, there would be disadvantage. Disadvantage in this sense. Let me take a few steps back and go to my university days, and I must immediately apologize to commissioners to the extent that I will now sound like I'm blowing my own horn. At Rhodes University, as students, we were quite a small faculty in my years. I think we were around 25. But I could, without any fear of contradiction, say I am certain that I was within the top 3. Students who gave me a run for my money were Bede Harris and Myron Zlotnick. The few distinctions that I got at Rhodes University would qualify as what is known as commercial law. But when I went to practice, did I ever get commercial work? No, I did not. And we all know what that is a function of. It is a function of the South African economic situation. Who holds the money, in whose hands is the wealth, and therefore in whose, or who generates that commercial work? It's obvious. So the closest I got, or before going to that, now if I had performed as well as I did in my LLB at university, even including in commercial subjects, what would have stopped me from excelling in commercial practice? I do not believe that anything would have stopped me. I did not get that commercial work in practice. The one case that could have qualified as commercial work, listen, I was in practice for years and years and years, and I'm talking about one that I remember off the top of my head, was a matter in which I was led by the late Justice Sikweya. The closest we got to commercial work was matters involving the law of contract and debt collection. You remember your colleague, Mr. Humphrey Lusu, he gave us a lot of work from the company that owned the Sparks Holdings, which was called RNE Holdings. And of course, we got a lot of work from you as well, acting president, and many other attorneys. But it did not truly qualify as commercial work. Where am I going with this? So we did mainly administrative law work, constitutional law work. So when you come in, and also, other colleagues in practice did RAF work, other colleagues did only criminal work. Now you come to the bench. You will, at the initial stages, you will definitely be disadvantaged. But take, for example, the Constitutional Court, we had the matter of Ascendis versus Merck, and you hear these concepts about inutility and lack of innovation, this and that. You have to sit down, apply your mind as seriously as you can, and try to get on top of things. You just have to do that. But you are at a disadvantage because somebody who has practiced that kind of law, they already know what that concept is, what that other concept is, and they start far ahead of you. You start way behind. But I emphasized the point that initially you are at a disadvantage because with time and as you get exposed to this kind of work more and more, and if you apply yourself hard enough, there will be catch up. You should be able to catch up. I don't know to what extent I have answered your question, Judge President.
Yeah, no, you did,
Yes.
and maybe even Sajay can play a role as part of judicial training.
Yes,
To empower those so that they should not be disadvantaged for purpose of promotion or ascending the ladder within the judiciary.
Yes.
Yeah. On a side issue, you did mention that at least for the latter part of last year, you were sort of part of leadership of the court, Constitutional Court. You were presiding in most matters.
And I chaired virtually all conferences.
Of
So
course.
I actually performed, you are quite right,
Yes.
Judge President. I performed without any title, not even as an acting Deputy Chief Justice. I performed the functions of a Chief Justice.
That should have given you an indication about the respect and the command you have over your colleagues in the court. Can you say anything about that?
I believe that I do command the respect of my colleagues. Both permanent and acting colleagues do approach me on the side for my views, sometimes just on process matters, but in particular on cases themselves, judgments. And if I will not embarrass you, you are actually one of those colleagues who have approached me on what I think. And I might even place it on record, Judge President, that where maybe, and I guess because of the problems or issues associated with the delays, where maybe there has been a bit of delay on my part to comment on a colleague's judgment, on occasion, some colleagues will approach me on the side and literally ask for, I don't want to put it higher than that and say demand, but ask with a bit of insistence for my views on draft judgments. So I would say that that is an indication. And as I said, and I want to emphasize this is not just acting colleagues, but it is permanent colleagues as well. I want to say that this does speak to the respect that I command from colleagues.
Yes. Just to clear the air and to eliminate any form of confusion, these are on matters that you with the colleague presided on.
Yes, yes, quite true. Yes. But in fact, I must say though that this is something that has been happening even before I started presiding. For a while now, colleagues have sort of been approaching me for my views, and of course this has continued even when I have been presiding.
I see. Okay, something that I do not recall you mentioning in your vision. How do you propose to deal with the media as the Chief Justice?
Now you want to put me on the spot, Judge President. Uh, this is a subject that raises constitutional issues. Section 16 of the Constitution, to be particular, from both sides, there is the one side being people who raise issues against the judiciary in the media, and the other side being how, if at all, the judiciary should respond. And all these, as I say, turn on what the Constitution says. And Section 16, as you know, guarantees each and every one of us the right of freedom of expression. So we should never lose sight of the fact that people are entitled to criticize us. We are not beyond criticism. And criticism can and at times must be robust, and we just must take it on the chin. But sight should also not be lost of the fact that we perform an important constitutional function. We are, after all, the ultimate arbiters as to what is lawful, as to what is constitutional, and all of this turns on the rule of law. For South Africa to continue being a country that respects and subscribes to the idea of the rule of law, courts should continue to function as courts and in the manner in which they should be expected to function. Where am I going with this? The criticism, which I immediately acknowledge as I did at the beginning, the criticism should never go to a level at which it will bring the courts to a state where they no longer enjoy the respect that they should enjoy from the general populace. Because once that stage is reached, then one may just as well say that the idea of the rule of law in South Africa has gone out through the window. So the judiciary should continue to enjoy the legitimacy and the confidence that it should have in order for the rule of law to continue functioning properly. So as much as I accept that there should be criticism, it should be criticism, one, that is fact-based, and two, it should not be criticism that is for no other reason. One, not being fact-based and calculated to bring the entire edifice of the judiciary into disrepute. After all, as both Chief Justice Mohammed, speaking extra curially or outside of court, and Justice Correctional speaking in court in the matter of Mamabulo. The judiciary does not have a purse, it does not have police, it does not have an army. It depends on the legitimacy that it enjoys, the confidence that it enjoys. Once a level is reached where people criticize it in a manner calculated to bring it into disrepute, that takes away the one thing that makes it possible for it to operate. Now, let me come into the last part of your question, what should we do? There is a lot of learning on the subject, and that learning does say that, well, judges also, as I think I said in my preface, do enjoy freedom of expression. But for them, there are certain limits, and for good reason. Those limits are at, for example, 2 levels. The first level being a judge should be careful, for example, not to comment on court-going matters which would give an impression of the judge being biased. That should be clear to everybody. Then there is another level, and in a sense, it is related to the first. And both these issues go to the question of the independence of the judiciary and the need for it to conduct itself in an impartial manner. So the second aspect is provided for in the Code of Conduct, and it says that judges should not comment on political controversies. This is easier said than done, as the expression goes. In practice, it's not quite easy to grapple with it, but maybe it's quite easy, actually. The Constitution is such that there are lots and lots of political implications around it. The very idea that it lies with the courts to invalidate acts of parliament. Acts of parliament come about as a result of a political process. The very idea that courts can invalidate the conduct of the executive, starting from the president to ministers, that conduct is something that happens in a political context. And even when you, then outside of that, even when you look at the Constitution itself, take for example your socio-economic rights, those in and of, it inheres in the nature of those rights that there will be policy-laden issues. Even the very idea that because ordinarily when you take the rationality principle, you don't question the reasonableness of the conduct of parliament, for example, or whoever the actor was. But when you come to socio-economic rights, it is inbuilt in those rights that you actually look at what is reasonable. So a court can actually question the reasonableness of what another arm of state, parliament, or even the executive has done with regard to something that impacts on socio-economic rights. So I'm touching on all of this in the context of judges commenting on political matters. And what is the relevance of all this background that I have given? It is this. In the context of an adjudicative process and deciding whether or not the conduct of Parliament, the conduct of the executive, or even issues arising from whether what was done by the other arms of state in the context of socio-economic rights is reasonable. The issue of political questions is there throughout. Therefore, in that context, because you are adjudicating a live case before you, you cannot avoid, in a sense, but of course, you are concerned with what does the Constitution say? And if where it takes you is to knock out or invalidate a political act, so be it. It is fine. That is our constitutional architecture. But outside of that, that is where then issues arise. But we are in the fortunate position that the Code of Conduct says, steer clear of that. Steer clear of that. Now, back to the broader question, what do we as judges say in the face of, for example, that criticism that I said may get to a level where it is unacceptable? What do we as judges do? I said there's a lot of learning on this, and there are differing approaches. And the one approach is that it may be something that should be dealt with at a leadership level, and that is an approach, for example, that Chief Justice Mogoeng used together with or accompanied by Deputy Chief Justice Moseneke and I think President Mpati, if I'm not mistaken, and they approached the President Zuma at the time, at the level of, that is Chief Justice Mogoeng as the head of one arm of state and President Zuma as the head of another arm of state. And out of that process came out a joint statement in which there was agreement on what is acceptable criticism and what is not acceptable criticism. Now, I am sure that a follow-up question would be, but is that the only possible approach? On the learning that I have gone through, it is said that a leader of the court may be entitled at times. It is not something, we cannot all the time run to the media all the time. But there is a lot of learning that says, in certain or under certain circumstances, the head of the judiciary, it may be perfectly proper for the head of the judiciary, under certain circumstances, to go out there and address head-on the unacceptable criticisms, the sort of criticism that, if allowed to go on and on and on, might have the effect that I earlier outlined as being, or potentially being injurious to the very idea of the rule of law.
I see. Thank you. And then at another level, or the second leg of the question would be, there is a lot of misinformation about the functioning of the courts and how cases are decided. And one cannot expect the Chief Justice or the leader of the judiciary to be addressing the media from time to time on these other minor issues, but which are so important to the public to understand what is happening. An establishment of an office within the heads of court, chaired safe by a retired judge who will deal with all these minor issues to conscientize the public of the functioning and what is happening in the courts. Can that not be of assistance? It's just a thought that came to me. I was just bouncing it
As
on
I'm
you.
speaking, my understanding, I will not reject that at all, Judge President, but I will add this and say, my understanding has always been that within the OCJ, there is an arm that handles the media. I think they have a certain expertise of dealing with the media. So perhaps what about merging your idea with what is already in place? That focal point, the focal point that you prefer should be or rather you suggest, you don't prefer, you suggest, should be a judge. What about that focal point? Be getting all these issues, and then with the experience of what we as judges do, then filtering it through to the OCJ, for the OCJ to then be the entity that actually goes out. I see no problem with that because the OCJ is our own entity. It is an entity that exists to support us as the judiciary. I do not know how
No,
to
that's
think
what
or
I
how
had
to
in
think.
mind actually, and say we always react to what is there in
Yes,
the public, but we
yes.
don't take proactive action
Yes,
as the judiciary
Yeah,
for
yeah.
public education. on that.
But as you say, caution should be exercised. We cannot all the time. There's criticism of this. We run and we try to react to that. Again, there's another criticism. We run and we try to react to that. We should be careful not to do that. Yeah.
Thank you, Acting President.
Thank you, JP Tlaletsi. Justice Madlanga.
Thank you,
could
Judge
I-
President. Yes.
Could I ask you please to be concise in your answers, bearing in mind that I still have a long list, about 20 of members of this commission who have indicated that they have questions for you, whilst at the same time, adequately responding to the questions. But
I will try to do my best.
do your best to be concise.
Thank you, Acting President.
Commissioner Dodovu.
Thank you very much, Commissioner. Good morning, Justice Madlanga.
Good afternoon, Commissioner.
Are you good?
I'm good, thank you very much. How are you, Commissioner?
Firstly, let me start by saying I looked at your profile, your record throughout your career. It is quite impressive.
Thank you, Commissioner.
You were admitted at a very young age as an SC, as a judge. You resigned, you chaired important commissions, or you were part of the important commissions in this country, and ultimately you became a member, you became a judge at the Concord. Very, very much impressive. I also read some of your judgments.
Thank you, Commissioner.
I missed something, and I want you to allay my concerns.
Yes.
Out of all of this, I don't see your leadership role. And this position you are applying for, it is leading the judiciary in this country. What is your take on that?
I will say there is demonstrable evidence, Acting President, please forgive me on this one, because it goes to the core of why I'm here. I will not be able to be brief. Please allow me. Thank you, Acting President. There is demonstrable evidence of my leadership skills. I have led at various levels, and let me emphasize upfront that I have even actually led a court. I was acting judge president in Mthatha. Let me quickly itemize the things that I have done in leadership positions. I was for years a member of the executive committee of the Transkei Advocates, Transkei Society of Advocates, and then second, I later became its chairperson for 2 terms, and I could only have been retained because there was a feeling that I could lead. Third, for 3 years, I was deputy chairperson of the Competition Tribunal. That is an entity that is as good as a court. Fourth, before my appointment to the Constitutional Court, I was chief evidence leader in the Marikana Commission, leading a team of 7 counsel, 3 of whom, including myself, were senior counsel. And what I must highlight in this regard is that it was not only about the leadership of my 7, we were a total of 7 counsel, leadership of my team. But I also exercised functions that related to the entire operation of the commission, that is outside of the chairing part. And I think Advocate Mpofu will support me on this. He will remember that I used to chair meetings, and there were quite many, of all those legal teams, and that was, we were far more than the people gathered here. Many advocates, many attorneys, those who remember, you will remember us sitting on stage when we were still in Rustenburg. When we came to Pretoria, you couldn't quite see because the attorneys, the advocates would be mixed up with everybody in the gallery. I chaired all those meetings, and lawyers being what they are, those were very difficult meetings, but I think I did my job well. But of course, it is Advocate Mpofu who would be able to comment on whether he agrees with it. Of course, he and I, at the level of counsel now, we had our skirmishes and boxing matches. Fifth, I am now in my 5th year as editor-in-chief of the South African Judicial Education Journal, a demanding job. 6th, I am currently co-editing with Judge Dambuza a book to be published to mark 10 years of the existence of SAJA, and I am heading that team. And contributions are going to come, that is, chapter contributions to the book are going to come from fellow judges. 7th, and most importantly, as I said at the beginning, I did lead a court as acting judge president of the Transkei High Court with tangible results. With tangible results. A leader, all that a leader needs to do is to come in and do 2 things in the main. There may be a whole lot of others. 1, decide where you want to take the institution. And 2, identify problem areas and come up with solutions for those problem areas. And then the next step, we should also be immediate. Implement immediately. I came up, I did not act for a long time, but I came up with tangible results, and one worth highlighting is that there used to be bottlenecks at circuit courts at the Transkei High Court. Circuit was done, a circuit would only be for a week. And judges hardly ever finalize cases. They would pick up part heads. I came in, I immediately identified this as a serious problem, and I decided there and then to increase circuits to 2 weeks. Yes, 2 weeks is not that much from 1 week, but because we were a small division, it would have been difficult for purposes of what happens at the center in Mthatha itself, to have judges out on circuit for long periods of time. But that one small change did bear fruit, and it did so immediately. Judges were better able to finalize cases and picked up lesser part heads.
Okay, I'm clarified. I want to follow up that question.
Okay, all right.
Yes.
Yes.
And people who will ultimately, or who occupy a position you applied for, must possess a modicum of good temperament, a modicum of good judgment. Do you think that you have a good state in that respect?
I believe I do, and I think people who have worked closely with me before would attest to that. I think acting President Petse, I think Justice Tlalesi there, and even as advocates, I would say Advocate Mpofu, Advocate Madonsela, whom I even led. I think all of them will attest to that, I believe.
Okay. Now, one of the points that Justice Peter raised about the attacks on the Concord is that of the quality of judgments. And he said, those who criticize the Concord says, sometimes you are incoherent, your judgments lack reasoning, and you use strong language, and sometimes you are very combative. And I want to check with you, do you believe in that? And if so, how can we improve and mitigate that kind of situation?
Let me say that it's very difficult at the level of the comments about incoherence and so on. It's difficult to grapple with it, not knowing the specifics. But to the extent that there is a basis for criticism, I want to say that with the new system that we have introduced, and which I believe is going to free up a lot of time for us, we are going to be better able to focus at what we do, attend with a bit more detail to our judgments, and even the editorial errors, citations and so on that we have even been criticized for, and quite correctly. I think with a lot more time on our hands, we will be able to address those. On language, there again, I think I would prefer to have specifics.
Okay.
I thought we are fairly collegial towards each other. Yes, sometimes you may be strong in your opposition, but yeah, I think I would prefer specifics. Yeah.
Okay. Now, when
Apologies, I'm sorry to intrude Commissioner Dodovo. I just want to ask Justice Madlanga to please pull the mic closer.
Oh gosh.
Because some commissioners are battling to hear you.
Oh, I'm so sorry. Am
Okay,
I
now-
better now, Commissioners? My apologies.
okay, now when you shared your vision for the judiciary, you mentioned how you can improve case flow management, emphasize on issues of mediation, systems that must be put in place, and so on. In short, just share with us your vision for a transformative judiciary that takes into account the realities of our country. Just brief.
That is an issue that is linked to a whole lot of facets of the South African economic, social, or perhaps socio-economic situation. And right now, when you maybe have ideas around certain things, there are also, right now the problems of this cannot be done because there are no resources. I raise this in this context. It is a reality, unfortunate though it may be, that somebody who is not legally represented will not be able to marshal their case in the same manner as their opponent, if their opponent is legally represented. Now, if we did not have resource constraints, there could be a way of trying to make justice or access to justice to be a reality. Yes, it is so that on the criminal front, there is Legal Aid South Africa, and which comes in automatically in criminal trials. But with civil cases, there is the needs or the need test, and the vast majority of South Africans do not qualify under that. Somebody who could be classified as poor will easily be said that no, you are too rich for us to be able to assist you. So they fall off the net as long as you do not meet that needs test. So whatever ideas one might have with regard to trying to address the problem and to even out, legal representation before us, you will always be hit by the problem of resources in South Africa. And I must admit that I am unable, as I'm sitting here now, to wrap my mind around how do you practically address that.
My last question. Criticism versus attack. How do you separate that? For me, I think there is a thin line, or it depends on how you view it.
I would not distinguish between the two. I think for me it would more be the content. It's more the content, because some people may say this is an attack when all it is it's criticism. It's more the impact. Does it reach the level that I earlier referred to when I was responding to Judge President Tlaletse?
What I wanted to establish was since the advent of our new democratic order in 1994,
Yes.
with the transformation of the judiciary, do you think the participation of historically disadvantaged individuals have improved the situation of transforming the judiciary as it ought to be, or not?
The short answer is yes. This is also a subject I have written on and published an article on. Out of several points that I make in that article, I also say that transformation is not for transformation's sake. You know, it's not just about having the different colors or races, but a person's outlook on life brings something to the table. I, as a black person, or a woman as a woman, may have a perspective or idea about a matter that may be totally different to, in the case of a woman, to a man, or in the case of a black person, to a white person, you know. And a case can actually turn on those perspectives. And as a man, I may completely miss something that a woman would see. And as a white person may completely miss something that I as a black person would see, and vice versa. And I will not use the vice versa when I'm addressing the question of, you know, the women. Because we as men, and because of how we have been brought up and how we view them, you know, patriarchy, misogyny, sexism, there may be a certain idea about women. And I'm not apologetic about this, and as I've said, I've written about it and written against it, you know. Women may see things differently from us, and I'm advocating for us to push ourselves as hard as possible to also see things the right way. So yes, there has been transformation, and not just that, practical value in it.
Thank you very much. Thank you very much, Justice Peter. Thanks.
Thank you, Commissioner Dodovu.
Follow up, Justice Peter. Lamola.
Yes, you may proceed, Honorable Minister.
Yeah, thank you, Justice. When you answered JP Tlaleng, I understood you. But now when you answered Commissioner Dodovu, you have left me a bit confused on the issue of criticism and attack. I want to get your view. What is, in your view, should be deemed or viewed as a constructive criticism or criticism, personal attack, or even insults to a certain extent, and who should determine it?
Minister, I guess the point I was trying to make is that I'm not sure that I want to focus on the tags. It is more, one, the effect, and two, the content. You may classify it as an attack or criticism, but it's more the content. For example, something that is completely factually unfounded. But because people are not aware, and because people will not all go to the source material, or will not be able to interrogate it, but will just take it at the level that it has been said. And it is also quite important, who says it, you know. So the impact that it will have, possible impact that it brings the judiciary into disrepute in a manner that may adversely affect the rule of law. That for me is the issue. And whether you call it attack, you call it criticism. And I think when I was talking, rather responding to Judge President Tlaletsi, we were talking criticism throughout.
Thank you.
Just a follow-up.
Thank you, Minister.
Commissioner Malema.
So, Justice.
Good afternoon,
Thank
good
you.
afternoon, Commissioner.
No, I didn't want to come in now, but you raised a point earlier about, which was raised by the acting president, about the huge criticism on the Constitutional Court, its inability to deliver judgments on time, right? And you came here and said, well, you are correct, we are unable to deliver on time, but this is what is going through. So if I say the Constitutional Court doesn't deliver judgments on time and all that, and I'm a layman, I'm not inside there, will I be attacking the court, or will I be justifiable to say the Constitutional Court is delayed in delivering its judgment? Would it not take a good judge and a good leadership to accept that, no, you are correct? But the reality of the situation is that this is what we are confronted with. But some short-sighted politicians may see that as an attack on the judiciary, because I liked what you said earlier on. No, you are correct. We take long, but this is what we have been subjected to. And in responding to that, this is what we're coming up with to resolve that problem. But some myopic leaders here have been actually attacking those who say Constitutional Court takes long to deliver judgments. Is that an attack, or is it a constructive criticism?
That's constructive criticism. Had I not been taken off my script on my vision by the acting president, asking me questions that relate exactly to this, in my note here, in my opener, dealing exactly with that point, Commissioner Malema, in so many words, I say, this is fact and I accept it without question. So I would take that as constructive criticism. Thank you.
Thank you, Commissioner Malema. Commissioner Magwanisha.
Thank you, Acting President. Good afternoon, Justice Madlanga.
Good afternoon, Commissioner.
I just have a few questions. One, bearing in mind that your vision must be translated into strategy and to plans. And in that process, there might be resistance to change. Will your vision be implemented in 3.5 years?
In my view, 3 and just more than, of course, depending on when the president makes an appointment. 3 and about 3 years and about 6 months, in my view, is actually a very long time. And I want to say, please just bear with me, Commissioner. Where's this? Yeah. I do not, for example, I do not think that my vision will be things that are so unrealistic that they are likely to meet up with a lot of resistance. But as I said, either right at the end or at the beginning, nobody has the monopoly of wisdom. I am going to consult with the heads of court on the ideas that I have. And as part of my vision, I have also said, I will get ideas even from the heads of courts themselves, so that what comes from them is, in a sense, part of my own vision. Logically, therefore, there will not, or it is unlikely that there will be any resistance with regard to ideas that come from the heads of courts themselves. And by heads of courts, I'm referring to all levels, from the Supreme Court of Appeal to the District Magistrates Court. And with regard to my own ideas, I will try to push for them. I could spin your question, Commissioner, and say, if a point that you bring to the table, because you are saying, if there is resistance, if there is no acceptance, I could say you may have 12 years as Chief Justice, but that does not guarantee you that that which is seen as unacceptable will suddenly become acceptable just because you have 12 years. So I come in with ideas, I try as hard as possible to sell them, and I implement immediately. And I want to say, in countering this idea that 3 years is short, I want to say that there are examples of people who have turned around courts or improved on them in less than a year. I'll give the example of somebody who is well known to this august body, Judge President Benenge, who is the Judge President of the Eastern Cape, and who has made the Eastern Cape High Court to be one of the better performing high courts. I have also said that I myself, as a leader of a court, even if in an acting capacity, was able, within a very short space of time, bring about changes. So 3 years is a very long time. As I said in response to another question earlier, all that you need to do when you come in is to decide where do you want to take this institution and what are the problem areas, how do you address them, and you implement immediately. When you depart after 3 years, 6 months, or whatever the period is, templates are there, and those templates are not likely to be thrown out by your successors just because they were made by you. If they are good templates, those will have lasting effect. Chief Justice Mogoeng is the one who brought in case flow management. He's the one that introduced Court Online. He's the one that put together the norms and standards. We are not going overnight to just throw them away because they were introduced by him. Question is, will I within that period put on the table templates that are workable and will have a lasting effect? Thank you, Commissioner.
Thank you, Justice Madlanga. Have you led in a situation where there are different stakeholders with competing interests? And how have you protected the interest of your organization whilst promoting sound relations with other stakeholders?
I think you may have seen in my CV that I actually led an entity that was called the Exchange Control Amnesty Unit. At the beginning we were 9, and in the end we grew to 25 as Amnesty Unit members, but the entity itself had a staff complement of around 100, and which I led with success. It had different interest groups in the sense that there were half of the officials were from SARS and half were from the South African Reserve Bank. And yes, it was a project pushed by both sides, but the interests and the ideas were not always the same. And I led that with success, and at the end of that project, the Deputy Minister of Finance, then Jabu Mleketi, spoke very highly of how I had led that process. I actually have the quote of what he said somewhere here, but I will not go into that.
Thank you very much, Justice Madlanga. SADC is faced with a serious threat of terrorism. Do you think that this might have an impact on our jurisprudence? For an example, the issue of individual rights versus national security.
I do not, I must admit, it's not a question that I've applied my mind to, but I do not at the moment see how it would affect individual rights, at least in South Africa, not at this stage.
I think the last one, how will you strengthen relations between the Judiciary and Parliament, in particular the Portfolio Committee on Justice and Correctional Services?
I would say that nothing beats interaction, Commissioner. And I understand that you chair that, that committee right now. Nothing beats interaction. I would definitely try to engage when there is a need to engage and discuss matters of common interest, of which there are many, because your committee and the judiciary are both concerned with justice. So.
Thank you very much, President. Thank you very much, Justice Madlanga.
Thank you, Commissioner.
Thank you, Commissioner Magwanisha. Commissioner Singh.
I hope it's just before lunch, Acting President. Thank you very much. Good afternoon, Justice Madlanga.
Good afternoon, Commissioner.
I want to start my first question with what the Honourable Minister asked in the beginning about the arms of state. And we know what the three arms of state are. And to the extent that a vote 27 was established and proclaimed by the President in 2010, the Office of the Chief Justice, my view, and you can tell me if I'm wrong, is that one would think that that vote came about to give the judiciary and the Office of the Chief Justice its independence, because it is an independent arm of state.
Yes.
Now, I heard your responses to the question by JP and the Minister itself, and maybe the Minister won't like your answer, depending on the answer you give. Because my view is that the budget of that vote should be directly under the control of the Chief Justice, with the Secretary General being the accounting officer. And the reason I say that, there is a saying that he who pays the piper calls the tune. So I'd just like your view on how the independence of the judiciary can be established if the budget which controls vote 27 places the minister as the executive authority of that budget.
I must say, maybe because of how I have been schooled as a lawyer, instinctively I just have problems, you know, as a judge, and two, if I'm appointed as a Chief Justice, to the very idea that there's a budget, it is under me. And if it is under me, it places me in a position of having to yes, you say the accounting officer will be the SG, but the notion of, you know, this budget is under me, I think it places, of course I'm thinking off the cuff, it just instinctively, I just find that a bit difficult for me. The idea of, in a sense, having something to do, even if I'm not controlling it, but the very idea that you are I'm sort of in the same position as the minister with regard to that budget. I have difficulties with that, but it's something, if appointed, I would try to apply my mind to. So I'm not outright dismissing the idea, but this is just my instinctive reaction. Yeah.
Thank you for that you're not dismissing it. I think it's something that one needs to engage with.
Yeah, and I guess there is also the so-called international best practice. So one could even look at what other jurisdictions do in this regard, and that could help inform the decision that one takes ultimately, Commissioner.
The reason I raise this, it's also applicable in another arena where we serve, and the Honorable Speaker would know about this, where the executive, the cabinet, is accountable to Parliament, yet the budget of Parliament falls under an executive member, which is the Minister of Finance. So there's a bit of, who controls who. Parliament should have its own budget and be able to manage its own budget and not be constrained by what the executive has to tell us in terms of how much money we get. But I'll leave it at that one.
Yes.
The second question would be about the delays, and I think Honorable Commissioner Malema spoke about the delays.
Yes.
Now, justice delayed is justice denied. And I know of some, I was informed of a case, Masugu and others versus the South African Human Rights Commission, for which for the last 2.5 years there hasn't been a judgment.
The initial hold-up on that one, though, was the Kwelane matter. The Masugu matter, I did not sit in that matter. I recused myself because of a prior engagement as counsel in another matter a while ago, but the issues were related. So I'm not mentioning that to say, no, don't blame me, not at all. But the reason for the initial hold-up was in Masuku, on my understanding, there was no constitutional attack. I think it was more about the utterances themselves. Whereas in Kwelane, there was a constitutional attack. Now, if Masuku had been decided, put it this way, if Kwelane were to invalidate, which it partly did, the act in issue, then that had an impact or a bearing on the Masuku matter. So the Masuku matter was shelved until the Kwelane matter was decided. So it was only after Kwelane had been decided. And I do understand in practical terms it would have been difficult for my colleagues to even start writing the judgment. You are writing the judgment going which direction? If Kwelane is still being written, it's in the pipeline. That is my understanding of the delay in, at least as I say, the part of it.
No, thank you for that, Justice.
Yes.
And you see, it brings me to the question of modernization of the judiciary.
Yes.
Now, you are in the hot seat, and I'm sure you must be also thinking about the day you'll sit in the seat of the Chief Justice, if the President approves your appointment. Have you given any thought to how you would like the judiciary to be modernized in keeping with other countries, African countries, countries outside of Africa, so that perhaps, COVID might have been a good thing and a bad thing, because it brought with it the virtual sittings. Now, have you any ideas of how you would like courts to function in the future, so that these delays do not take place and you make it more friendly for law practitioners, for litigants, etc.? Have you had any ideas? Do you have any ideas that you can place on the table in that regard?
If we did not have the two seriously different I will loosely say, communities in South Africa in the sense of the haves, have-nots. One would have said the best is caught online, what I described earlier, and I will not go into detail with that. But I immediately said there are problem areas there for the reasons that I highlighted. In the so-called developed world, this court online works like a gem. It works perfectly because even the youngest child is computer savvy and all of those things. So, and also, they do have the resources. Everybody has access to all of these things. So with us, the problem always goes back to resources, access to money, and the use of it. But as you said, even at the level of judges, my understanding is that there was resistance to court online, but uptake increased as a result of COVID. So in a sense, COVID had positive results. So, but because there has been that initial uptake and acceptance, it should be much, much easier for other courts to accept the system. But one would have to apply one's mind on how do you address these two worlds. But the problem is, and I think it's quite fundamental, the problem is it will probably go back to resources again.
Thank you. I've heard the word resources many times. I think we've all heard the word resources many times. And we understand the constrained resources that the country is facing to.
Yes.
But if we want to deliver a judicial system to the people out there who don't have to wait for years, who don't have to languish in prison, bail for years on end without the matters coming before court, then, Honourable Minister, we need to do something about resources. And you've got parliamentarians here that will support an increase in that budget. So we just hope if you are appointed Chief Justice, you'll have a serious engagement about resources with the Honourable Minister. My last question relates to the safety of, there are concerns about safety of judges, of witnesses, those in witness protection. What ideas do you have? What can be done to ensure that there is a relative degree of safety of judicial officers and people who are whistleblowers?
Commissioner, let me not even try to pretend to be clever. That is an issue. I have not applied my mind to that. I will not pretend to have any answers or try to think off the cuff.
Thank you, Acting President.
But certainly it is something that if appointed, now that you've raised it with me, I would definitely apply my mind to.
Thank you.
Thank you, Commissioner Singh. Is it perhaps...
No, on a follow-up. Justice Madlanga is, I don't think you need to apply anything on it. You are there, you are in the space.
Yes.
Maybe let me put it differently. Is there a security threat on judges?
I am aware that there have been incidents which of course have not been and could not be publicized, but on my understanding, quite few. But if there is, there are the few, that in itself should be cause for concern. But I must confess, I am not at all aware of the details. I'm not aware of the details.
Thank you, Commissioner Malema. Could we take just one commissioner before we adjourn for lunch? And that will be Commissioner Nwambi.
Thank you, Acting President. Afternoon, Justice Madlanga.
Good afternoon, Commissioner.
Let me also join Commissioner Dodovu to commend you for your achievement.
Thank you.
But-
Thank you, Commissioner.
But also as somebody that was once a commissioner that used to interview people in the past, I think you are too modest about your achievement, and don't be apologetic. We are marketing yourself. You know very well that you are spoiled for choice. We have the creme de la creme of jurists in South Africa for the entire week. So don't be apologetic in dealing with the 18 that will be coming after myself.
Thank
So
you,
my-
Commissioner. Thank you.
My first question, it's as we know that this is a leadership position.
Yeah.
We're talking about somebody that will be in charge of judiciary, not only judiciary, but also this very same body that is interviewing you, somebody that will be chairing the JSC. If you can share with us your understanding of immediate challenges facing judiciary in South Africa that need some special immediate attention.
I would say it's what Commissioner, the main one of the main, what Commissioner Singh touched on. And I think also when we came back after tea, as the acting president was beginning to say, he's going to call upon commissioners to come in with their questions. I said I just want to add something, and that something was something that Commissioner Singh touched on, which is the question of delays. And there's the hackneyed but useful phrase that says justice delayed is justice denied. That is an issue that I mean every judge, every judicial office, everybody who is associated with the law, and even ordinary observers, that's something that is quite a problem that needs urgent attention. Yeah.
Thank you, Justice Madlanga. The second one, it's maybe if you can make some of us to understand your view about the value of a dissenting judgment.
There's a saying in legal circles that a dissenting judgment of today may become a majority judgment of tomorrow. Let me very uncomfortably say this. You'll recall that I said that on 31 December 2021, I delivered a judgment. In that judgment, I quote copiously from dissenting judgments by Justice Mohoro, Justice Yvonne Mohoro, Justice Kate O'Regan, and Justice Albie Sachs. Those were dissenting judgments, but it is those judgments that I agree with, quote copiously from, and I reach the same outcome that they said. Were we not in the minority, were we not a dissenting voice, this is the outcome we would have reached. And in my judgment, I reached the same outcome that was reached by a dissenting judgment. So, short point, there is value in dissenting judgments. But an important rider, we should never dissent for the sake of it. You write a dissent because you just simply cannot agree what the majority says. But my own belief, there is something that we call a hays besoek at the Constitutional Court, which for those who do not, I don't know Afrikaans myself, but I will know the odd term here and there. We call it hays besoek. So when we were still operating from the court, where you have a disagreement with a colleague, you just get up, go to that colleague's office, and you discuss back and forth your views, the colleagues' views, and see if you cannot reach common ground. And my experience is that on quite a number of times you are able to find common grounds. So those instances where there will be dissents, I believe it is on those occasions where colleagues cannot find each other, and for the reasons I gave, there is value in those dissents.
Thanks, Justice Madlanga. My last question, it's the issue of quorum at the Constitutional Court. You know that we will have our own sessions where we'll be doing the deliberations. We normally say in the absence of information, sometimes perceptions become a reality. So I don't want to have my own understanding of it when you said if you can be appointed, you can be able to assist, because it has led to an injustice in the past.
Yes.
Why will you wait for an appointment to be a Chief Justice while there's an injustice that is happening?
As they say, when somebody does not have an answer to a question, good question. Perhaps let me say, appointed or not appointed, it is, you are quite right, it is an issue that we must address. Minister, as the person that I understand would move a bill on this sort of subject, you have heard the problem, and perhaps let us take this as a formal tabling. I'm not a parliamentarian, but I will use the language and say, let us take it as a formal tabling of the issue before you, for you to please do something about it. And the other commissioners are also here, and I hope this is something they can support.
Thanks, Justice Madlanga. Thank you, Acting President.
Thank you very much, Commissioner.
Thank you, Commissioner Nyambi. Justice Madlanga, perhaps just as a follow-up, the provision of the Constitution says a matter before the Constitution must be heard by at least 8 judges. And the problem that you alluded to earlier on, in my view, could be resolved by simply adopting a rule of practice. It's 9 or 11.
With regard to above 8, if you remember, I separated my response to those situations where, as you say, we internally could find a practical way of resolving it. And I said maybe an amendment may not even be necessary, or it could be done, just as a matter of extreme caution, perhaps, to just have it stipulated statutorily somewhere. I even said it does not have to be a constitutional amendment. But the Constitution stipulates this for a reason. It has said 8. Do we, as the judges of the Constitutional Court, have the right to say, we are now 8, we cannot sit, come after a year or after whatever, when we will be able to sit more than 8? Something does need to be done with the 8. We cannot just continue, or on a continuous basis, continue operating at the level of a practical situation when there is this constitutional provision. I think something does need to be done about it. But otherwise, as I say, I do accept the idea of a practical resolution, or dealing with it practically.
Thank you, Justice Madlanga. I do accept that an amendment
Yes.
would be necessary,
Yes.
because you might have a litigant who is difficult, who insists that
Exactly.
if there is 8 judges,
Yes.
then they must
You must
hear
sit.
the
Yes.
matter.
Yes.
Thank you.
And especially say for example, the litigant who yes, the litigant who would gain from that if the judgment of the of the court appealed against will stand if there's an even split. That litigant could easily say, no, the Constitution says, so please go ahead, don't tell me about postponing to some other date.
Thank you, Justice Madlanga.
Thank you.
JP Tlalete has a follow-up question on the same topic.
Thank you.
Yeah, just a follow-up on this question. I think every judge of the Constitutional Court has got the right to sit in a matter. And now if you decide amongst yourself, who are you going to exclude? And what impact will it have? I mean, that will be saying, if Judge so-and-so was in that matter, then I lost my case. Thank you.
Those are other, thank you very much for that. Those are other considerations as well. Well, I may not have articulated as well as you do now, Judge President, but I did earlier say there will be the issue of who do you knock out and on what basis, but I think you articulate it even better. Yeah. Thank you, Judge President.
Chair, may I please have a follow-up on this?
Please do, Professor Schlemmer.
Good afternoon, Justice.
Good afternoon,
It's
Professor.
good to see you again.
Thank you very much. I'm happy to see you too.
The question that I have in this regard is, do you think there's still, or the reason initially why the minimum of 8 judges was put into the Constitution exists anymore? And the reason why I'm asking this is initially when the Constitution was drafted, the Constitutional Court as a new court was established to create constitutional law. Now the Constitutional Court has open jurisdiction, so anyone can bring an appeal to the Constitutional Court. Does that reason of having such a big bench exist since you are not dealing with the development of new law in the sense of initially with the Constitution and constitutional precedents, which we now have, but we also have that you are dealing with a lot of appeals from the Supreme Court of Appeal, which also causes me to ask, why suddenly are people not happy with the judgments that come from the Supreme Court of Appeal, and on what basis? I would like to hear your view on this.
I don't think it's let me start with the last part. I don't think it's more people being unhappy, more than they otherwise were. People will always take an avenue that they see. Now that they can appeal against judgments of the Supreme Court of Appeal, they will take advantage of that. And then with regard to the earlier part of your question, for as long as how should I put it? For a court of 11, or let me say, I think there is value. There is value in an apex court speaking with one voice, and in this sense, one voice, I do not mean, in an individual case, judgments being unanimous, no. One voice in the sense that there is a majority judgment in that case, majority judgment in that one, and so on. So there is value in that sense, that one voice in that sense. Yes, I know there is another criticism that we sometimes ignore or don't take into account our own precedent and so on. But all things being equal, what should ordinarily happen is, if you sit and punk, or all 11 of us, or at least 8, we have that precedent which, if all things are equal, we should follow all the way through. Unlike if we sit in panels, Yes, I know as a lawyer, you will immediately say, in particular as an academic commissioner, you will immediately say, but no, 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 no. You should be aware that panel A there decided another case this way, and panel X there decided another one that way. But the problem with that is, if that panel decided that way, as much as we should all be disciplined only to depart from earlier judgments if they are, what's the term we use, clearly wrong, even though there is that, but there is that fundamental thing that human beings being what they are, that I was not part of that panel, and I think they decided that case wrongly. It may be easier for another panel to say that that was clearly wrong. Let me give you a case in point. Justice Mhlantla, when she was still at the Supreme Court of Appeal, she decided a case, or rather wrote for the majority, deciding that way. Exactly a year later, same date, a year later, a different panel, of which she was not a part, decided another case on the same point completely differently. And I think that was exactly a function of the fact that the Supreme Court of Appeal sits in panels. I doubt that within a year, if they set and bank as the Constitutional Court does, they would have kicked away their own judgment within a year. I doubt it. So there is that value in sitting and bank. But I understand the point that if we sat in panels, we would go through our work much, much quicker. I understand that. Yes.
Thank you, Professor Slema. At this stage, we'll take the lunch adjournment. According to our schedule, it was supposed to be 1 hour long. Do we still stick to that? I make it 2 o'clock, which means we would then have to resume at 3 o'clock.
I propose that we come back at 3:45. So it's me, it's Madonsela.
Yes, I've noted you, Commissioner Madonsela.
I'm
I'm
proposing-
just looking around to see if there's any dissenting voice, and it doesn't appear.
I don't agree with that. You know, we hold very different and difficult responsibilities. And when you call us to come and spend a week here, we do so, but during lunchtime, we try and satisfy other responsibilities that we hold somewhere. So when you allocate an hour, we also put appointments in that hour so that we don't lose time. So I think that we have adopted the program as is so that we are able to perform certain duties in between executing these other important responsibilities. So I say,
I take your point, Commissioner Malema. You need not say more. We'll adjourn at this stage and resume at 2 o'clock. Thank you.
that concerned me about one of your answers. Maybe preface it like this, that at least in my book, the three broad areas that would qualify one for this position would be judicial skills and experience, and I'm quite satisfied in that regard. And that involves things like industry, independence, integrity, and so on. Then the second broad area is leadership and people skills. And again, you've said a lot about that. You've been questioned about that. Particularly managing lawyers is not an easy task. And I should imagine managing judges is even worse, of all different persuasions. But so the area I really want to talk about is the third area, which is the administrative and management skills and experience. I take your point about not being a super SG, as you say, and that you don't like budgets very much. But unfortunately, this position will require those things. You are, in a way, a person who's in charge of, for lack of a better word, an organization or a department. So do you have those skills? If you don't, will you be able to develop them? And by that, I don't mean you must do a BCom or anything like that, but just to be able to manage a budget and organization, and management in my book also would involve, or rather leadership and management would also involve your position as chairing the JSC, because that also is not just like sitting on the chair. It's about organizing the meetings, the dates, managing all of us here and all that, and interacting with the administrative staff. So if we talk about that, the kind of dry side of things, not the forensic skills and all that, where do you stand on that?
Commissioner Mpofu, if I created the impression that I'm saying all that my focus would more be leading in terms of, which is what I said, leading in terms of crafting a lasting and credible jurisprudence. That is not what I meant, but I did say, to me, that is key. But I by no means meant that should then take away the need for a Chief Justice to be a leader. I did not mean to say that. If I gave that impression, I apologize for that. But I would want to take issue with regard to the question of the actual management of the budget. Yes, of course, you as the leader of the Judiciary will know what the courts need and other aspects closely related to the courts. So you will have to have an input, assisted of course by other heads of courts at all levels, have an input on what should go to the budget, but without literally managing it yourself. I think as Commissioner Singh said, the accounting officer, even on the model that the Commissioner was suggesting, would remain the Secretary General. So I just want to qualify that one aspect. But focusing more on your point about leadership and administrative skills. Here's something that I want to emphasize. I have touched on a good few occasions on the aspect of me having actually led a court. I just want to again go back to the other aspect, which was not leading a court, but leading a relatively sizable entity, which, as I said, comprised around 100 people. Let me emphasize this about that, and it actually goes to the core of one of the things that I highlighted with regard to what I think a leader should do, leader in general now. That is being able to come in and decide where you want to take the institution. And two, if it's an institution that exists, being able to identify problem areas and come up with solutions. Now, the entity I'm referring to is that Exchange Control Amnesty Unit. That was set up by an Act of Parliament which gave the tag chairperson to the leader, and that I was appointed. But effectively, when you went through the Act, it had the effect that the chairperson was actually the chief executive officer of that entity. Now, what do we get in terms of facilities? National Treasury gave us a floor, literally empty floor. So I, together with the other Amnesty Unit members, started that entity from scratch. So this is where my notion of being able to identify where you want to take an entity to. So at a strategic level, we as the Amnesty Unit, under my leadership, decided where we wanted to take that entity. And at the initial stages, we ourselves, because we did not even have support staff at the beginning, had to take decisions even on mundane issues like, what do we want in terms of even office furniture, this and that, other facilities, your computers and blah, blah, blah. And then, of course, we had to take decisions at a strategic level. And there was resistance to this, because people were suspicious, very suspicious of it. And I had to go out to the public and sell the idea. I also invited interested groups. We received advocates, we received attorneys. Their clients, of course, nowhere in sight, you know, and they would ask hypothetical questions. How are you going to do this? And we had to sell that. And at the end of it all, it was a resounding success. And I want to look for what I said is on here, and which I said I wanted to quote from. Please just bear with me, Commissioner. But the emphasis I'm making is that throughout, this demonstration cannot only run with an existing entity, but I can actually start an entity from scratch. Here's what Deputy Minister of Finance, Honorable Jabu Muleti said at the conclusion of the process. Open quote, "I would like to take this opportunity to thank the Amnesty Unit for their sterling work. When the unit was initially announced, we did not anticipate the huge task it would be faced with, both in the number of applications received. We received in excess of 43,000 applications, and the associated logistics. And I might add that we did not have a single review application, and we did dismiss some of the applications. We did not receive a single review application. It is through the exceptional efforts and meticulous approach of our unit that other countries, and I want to emphasize this, now seek to use our amnesty as an international benchmark. I wish to specifically thank the chairperson, Advocate Mbuyiseli Madlanga, who has led the Amnesty Unit impeccably and with great enthusiasm. So I think that amply demonstrates that I do have leadership and administrative skills. And I want to complete this response, Commissioner Mpofu, by saying, to those that seek to emphasize, and this is something I've seen quite a lot in the media, those, not that I'm saying it's the media saying it, it's people commenting and saying so in the media, to those who seek to emphasize the idea that, but I lack leadership, I don't. I don't. And having started an entity like this from scratch, in an area, and I again emphasize this, in an area that was completely foreign to me, and I led it to success, how much more will I be able to perform in an area where I have grown up? I have grown up within the judiciary. I have been associated with the judiciary for 40 years. Anybody who wants to suggest that just because I have not been a judge president for 4 years, 5 years, 6 years, or at any other leadership of the judiciary for an extended period, therefore, I am not suited, I do not agree.
Thank you.
I do not agree.
No, thank you very much. In fact, that last part is exactly why I asked you the question, because, you know, I know you are all humble and collegial, but ultimately this is a competition.
One of the your colleagues, one of the commissioners, I think it was you, Commissioner, sorry for pointing at you, said I should sell myself. I guess I'm warming up.
Yes, yeah. He didn't mean that much. No. On a serious note, yes, because that is the point, as you have correctly alluded to. The fact is that the other candidates that you are competing with or against have demonstrable leadership pedigrees within the judiciary. But I agree with you that leadership is a much wider concept. And by the way, attest to how you led us in the Marikana Commission.
Thank you, Commissioner.
Now, the next area I want to ask you on is transformation. I don't have to give you any long introductions. You occupied the seat that I'm occupying here in the JSC for Advocates for Transformation. So you don't need to be lectured about the imperatives of transformation. But I want to link that to your feminism. You said you are a feminist. I'm a feminist too. But as you know, there are different types of feminists. And I'm a radical and socialist feminist. I don't know what type you are. But at least there's one thing that is common, which is the idea that it's no longer just about equality, but taking active steps to ensure that women occupy their place in society, not just within the profession. But let's come back to the profession. What have you done, or what would you do, maybe more importantly? Forget about what you have done. What would you do as Chief Justice to ensure that the idea of equality is not just lip service, and it's not just a numbers game. It's about qualitative change and infusing certain ideas within, or rather, and killing certain ideas that might be pervasive within the profession in particular, along the lines of In other words, what would we gain by having a feminist Chief Justice like you?
The practical difficulties are that it is more the profession itself that should fight those battles. It is my organization, I will still own it even though I'm no longer in it, Advocates for Transformation, in which you are. There's organizations like Babasa, it is even in the attorney's profession like BLA, Nadel, that need to fight those battles. I know that a retort might be, but we have been fighting them, but we are still where we are. But that's a fight that should never ever end. If anything, it should be intensified. The problem is always briefing patterns. I touched on it in the context of my not just myself, of course, but I use myself as an example. The problem is that it's a perennial problem, it's a systemic problem. But as a Chief Justice, what can you do? Maybe more engagement with the profession itself, and maybe selling the ideas of getting the profession at all levels to do some of the things, for example, that I, as an advocate at a transformative level, in practical terms, was able to do. So much that Advocate Nsaluba SC, in a letter of motivation at the nomination stage before the president, wrote this about me. He said, I do not only speak about transformation at public platforms or on podiums. And he says, I, and I quote, live, L-I-V-E, transformation, close quote. And what did he mean by that? What I used to do as an advocate was to try, to a limited extent, of course, because as an individual, you can only do so much. For example, in Johannesburg, I contacted him and I asked if he would have any problem if I mentioned his name, and he said not. In my Johannesburg chambers, and for an extended period, I accommodated Advocate Emmanuel Mukutu. He is now senior counsel. I'm not claiming credit for the fact that he's now senior counsel. But he had just started at the profession, and you will know that bar-use are the greatest barrier to entry or to entering the profession. And in my Mthatha chambers, I did the same. I accommodated Kwezi Mkuku, him as well, for an extended period. And how was this possible? It was possible because my practice took me all over the country. So it wasn't as if I'm there and I feel I'm crammed up. I was all over the country. So basically my chambers were literally theirs.
Okay.
That's just the one aspect.
Thanks. Can I interrupt
Yes.
you?
Okay.
And maybe it's because I know some of the stories. I'm quite satisfied with what you did.
Let me, yes. May I zoom in on your question? I was merely being...
Before you do that,
I'm sorry, Commissioner. I'm sorry, Commissioner.
Maybe
Yes.
I should focus the question. I'll give you a practical example. Justice Mogoeng,
Yes.
for example, and I think to some extent JP Mlambo,
Yes.
always told us here, or told candidates, that from the bench's perspective, I mean, we have all our gripes about transformation and the
Yes.
lack thereof
Yes.
in the profession. But from the perspective of the bench, Chief Justice Mogoeng would lament the frequency with which, for example, the state in the Constitutional Court is represented by white counsel, white males at that. And we've all been trying to find ways in which the judiciary can intervene. Of course, you're right, Pabasa, AFT, and so on must do it. But there must be a role for the judiciary itself And for example, JP Mlambo initiated a system where they would literally take names of who appears in which matter. I don't know what happened to that project. In a way, obviously, you can't just say brief this one or brief that one, but trying to nudge the balance. Yeah.
I was with that illustrative. Thank you very much, Commissioner Mpofu. With that illustrative, what I was trying to make is, or rather, the point I was trying to make was, the bar itself can do certain things, and that as Chief Justice, I would be willing, if appointed, to interact with the bar. Not just at, I mean, the lament of Chief Justice Mogoeng is a lament shared by all of us. I mean, at tea, we would sometimes whisper, just look at what is happening in there. I mean, it strikes us all. It strikes us to the core, all of us. So at that level, engage the leadership of all the professional bodies, those that I have referred to, and even the statutory bodies as well, led by you, Commissioner Jepu. Engage them and raise these concerns and see if it is possible to come up with practical ways. Because as I think you were saying about Chief Justice Mogoeng, we as the bench, we cannot tell whoever whom or who not to brief. We can't do it. But at the level of the professions, but the minister is here with us. From the side of the state, I do not know, but minister knows better at the level of, or rather in practical terms. I know in the context of a certain judgment in which I wrote a dissent, a figure was given that the set aside for black practitioners is 75%. That is what was said in one of the documents that served before us. But as I say, at the level of implementation, whether or not that is what is happening is something else. Those are the sort of issues that a Chief Justice would engage the professions about, and possibly even the minister.
Thank you, Acting President.
Thank you very much, Commissioner.
Commissioner Mpofu.
Thank you, Justice Madlanga.
Thank you, Commissioner.
Advocate Madonsela.
Good afternoon, Justice Madlanga.
Good afternoon, Commissioner.
I must put forward a disclaimer that you and I speak frequently and we are friends, and it is on that note that I have to declare that I know you very well.
Thank you, Commissioner.
But that won't help you. You have expressed yourself very firmly on the idea of the Chief Justice being an intellectual leader of the judiciary.
I consciously avoided that term.
Well, that's the impression you left in my mind. But I certainly think you are right about that a Chief Justice should be an intellectual leader of the bench, or the entire bench. But we as the public have no way of knowing whether you are really an intellectual leader. And you are, or you measure up to that standard. The only way one is likely to be able to ascertain that as a matter of assessment is with regard to what your colleagues say about you. And that will arise more readily from the dissent or judgments which you have written being concurred to by other judges.
Yeah.
Or the number of instances in which judges differ with you. On an average, are you able to indicate, with reference to the judgments you have written, as a member of the Constitutional Court, how many times or how frequently have your colleagues concurred on or concurred to your judgments, firstly? And what is the regularity of them dissenting on your judgments? And which of the judgments have you delivered which you regard as groundbreaking and, if I may say, pretty much authoritative in their breadth and ambit as to set you apart from all other judges in the country?
The last part is quite an ask about setting me apart from at the level at which this was pitched. But I am happy because I did not do an exercise myself, but I'm happy that the General Counsel of the Bar, I'm sure you saw in their comments, they actually do a very detailed breakdown on the question you asked about, dissents and majority judgments and so on. And what comes out of those comments is that by far, most of my judgments are majority judgments. I think by quite a substantial percentage. Where there are differing views in judgments, mine by far in terms of percentages are in the majority. And what is worth noting in that comment is that they say I have written dissents in only 4 matters, which means I was not able to command a majority in only 4 matters. That is what, as I said, I did not do the exercise myself, but that is what the GCB says. Then on groundbreaking judgments, I would say Paulson is, in this sense.
Is that Paulson versus Slipknot?
Yes.
On Duplum rule?
Let's leave out the Duplum rule. That was the very first case that dealt with our general jurisdiction. It charted the path as to how exactly we engage with the idea of our general jurisdiction. And that is the judgment that the Constitutional Court quotes day in and day out on our general jurisdiction. I would also say the judgment in New Nation Movement is also, I think, a landmark judgment, because it is a judgment that
on independent electorate.
Yes, that changes our, to an extent, of course, our electoral system. It introduces the change that you mentioned. And I would say also that even the Bwanya judgment that I delivered on the 31st of December 2021, I think it is.
The next question was in relation to that case, the Master of the High Court case, Bwanya judgment. I suspect it must have been the first time that the Constitutional Court ever overruled its earlier decision directly.
You're sorry.
And I want to ask a question on that topic because I'm thinking of the parties in Fox versus Robinson, the case which you overruled. How they feel about the outcome of that judgment now that
they were a few years earlier.
Yes. You have written before, as a judge of the Constitutional Court, about the importance of stare decisis as foundational to the rule of law, in that case, Turnbull
Turnbull
versus
Jackson.
Jackson case, which is also quoted often in our courts. As an apex court, as I said, you should speak authoritatively in a manner that chants the legal position for the courts below you, the SCA, the High Court, even the Magistrates Court, and all the courts. And what do you think should be the circumstances in which the court readily overrules its own early decision?
Commissioner, I will latch on to two adjectives that you have used. At the beginning of this question, you said did you say directly? Oh yes, you said directly overruled.
Yes.
And what was the last one? You said right at the end.
Well, I'm sorry, Justice Madlanga, I used so many adjectives.
Okay, anyway, let me just answer the point of substance. Maybe one will say it was all fancy footwork, but I do not read or understand my judgment in Buanya to be directly overruling Folks v. Robinson. But yes, I immediately accept that the outcome does, in a sense, have that effect because the outcome is the direct opposite of what Folks v. Robinson held. Why do I say I did not directly overrule Folks v. Robinson? It is because I say, one, before us in this case, there was something factual, something evidentiary. And I say Folks v. Robinson cannot bind us now on factual matters. So, bringing my mind to bear on the factual issues before us now, I am led to a different direction. That's the first aspect. Then the second aspect is, I also said, I read in the partial judgment by Kachalia J.A. a development of the common law, which was not there when my view on it. It's a matter of some magnitude. I'm not ducking the question, hopefully.
Well, my recollection is that the incident of increasing the jurisdiction of the court had to do with personalities who were in the office at the time.
Yeah. Oh, okay.
The strong personalities, the one heading the Supreme Court of Appeal, the other one heading the Constitutional Court.
Yeah. Thank you, Commissioner. I would just say it's something that one would have to really sit down on and apply one's mind to. As I say, it's a huge policy issue. Yeah, one cannot give an off-the-cuff response to it. I do not think. Yeah.
Thank you, Justice.
Thank you very much, Commissioner.
Thank you, Chairperson.
Thank you, Commissioner Madonsela.
Maybe follow up is Lamola.
You may proceed, Honorable Minister.
Yeah, thank you. On the same point that he has raised, I'm on the flip side of it. I think it was Justice Matopo in his last interviews. He suggested that we should collapse the Supreme Court of Appeal and make some chamber in the Concord and have one apex court. It's almost an opposite of what Madonsela was asking. What will be your view to that?
Because it's all, Minister, because it raises an issue that is closely bound up with the other issue. On that as well, I would say it's something that one would have to sit down and apply. It is so that the point that you raise, is not a new issue, and I'm sure when my colleague Justice Matopo raised it, he raised it also well aware of the discussions around it. When the late Chief Justice Ismail Mohammed was still alive, leading the Supreme Court of Appeal, and I was acting there, he was for the idea of a chambered apex court, one chamber exercising general jurisdiction and the other chamber exercising constitutional jurisdiction. And I, perhaps I may be speaking out of turn here, I do not think the transfer, for example, of the Chief Justiceship from Bloemfontein to Braamfontein would have been as easy as it was if he had not, unfortunately, passed on, as quickly as he did. That battle about the chambers would probably have gone on for quite a while. And maybe, who knows, maybe it might still not have been resolved even now, and maybe the Chief Justice, but he would have retired by now. So the short point I'm making, Minister, is that this is quite a complex issue.
Thank you, Honorable Minister. Justice Madlanga, don't you think that over and above the workload of the Constitutional Court, some of the systems or practices of that court are also contributors, to judgments taking longer to be delivered?
I agree, and in my note now, because after you had asked me certain things that related to the delays, I could not, because I would have been repetitive, go right to the beginning of my vision, go all the way down with it. I actually do have something that touches on the practices. For example, I say on there, and it is one of the proposals I am making, but which I am yet to table before colleagues, but it's already on the document that I said is final and maybe circulated in October or latest early March. And one of that is, I've repeatedly mentioned the question of a post-hearing note to you commissioners, and then a first draft by the allocated scribe. One thing that I think is wrong, which we do, and I suggest in the revised working procedures we should do away with, we, quite early on, there will be a colleague who indicates at the stage of the post-hearing note that they do not agree with an approach by the allocated scribe. But we rarely ever have the disagreeing colleague right at that stage. An opposing draft usually comes in after the second, sometimes even after the third draft. Now remember, I talked about comments at every stage. If an opposing judgment comes in after the second or third draft, now remember that there are going to be comments on that as well, and there will be a few drafts on that one as well. So it does lengthen the time quite considerably. Short point, I agree with what you say, that the processes themselves also do contribute. What do I suggest in the revised working procedures? I say, right at the start, colleagues, if there's disagreement, must engage each other as seriously and as heatedly, but I do not mean uncollegially, as possible. And even outside of emails, because as you know, when you acted there, you usually express your disagreement by email. But based on the proposal that I am putting forward, I say You may even go beyond just responding by email, because with emails you sometimes talk past each other. You pick up the phone because you are now not physically at court. You engage each other. Once you see that there is no way you will find each other, then the opposing colleague must have the exact same deadlines, as the allocated scribe. Then the timing of the judgment and even the final judgment, and as you know, on average, we have 3 drafts. So the third draft being what we call the read-through draft. So it means even the opposing draft, the deadline for those read-through and all, will be at the same end point. That will reduce the time quite considerably. Short point, I agree with you, yes, our processes do contribute, but in the working document, at least with regard to this one, there is a proposal that I am going to be putting on the table, and it is exactly what I've just said to you now.
Thank you. In fact, the one I had in mind when I posed my question to you, and which I had occasion to raise during my stint, was the unnecessary delays that happened after a judgment has been read through by the judges. I remember an instance where a judgment took almost 2 months after the read-through to be handed down.
I do not, because I do not know why it would delay it that much, because as you know, what follows after the judges read through is what are called clerk processes. So the clerks just do editorial work, dotting the T's, just checking, those, and even citations and things like those. And at the most, that takes maybe about 2 weeks, thereabout, give or take. So I have no explanation at all, and I do not even know which matter that was. It should not be. That's not part of our processes. I do not know what went wrong there. It should not be like that.
Thank you.
Thank you.
Advocate Kane.
Thank you, Acting President. Good afternoon, Justice Madlanga.
Good afternoon, Commissioner.
I am one of the commissioners on this commission that represents the practicing advocates, and so I obviously want to take up a few things with you out of the GCB's very glowing review of your work. The first aspect that you said you took very seriously was the question of the way women are addressed and how matters may affect them. And I thought that was laudable. My question relates to how the position of Chief Justice, if it were given to you, would enable you to take steps to enhance the dignity and the independence of women over and above the laudable manner in which you set about expressing yourself in relation to women. Let me premise it by this. Much of what you've said has impressed enormously as to, you referred to yourself as a trendsetter in writing judgments. My colleague referred to you as an intellectual leader. And that's a role you're already fulfilling and playing. So why is it that we should appoint you as Chief Justice? What would that position enable you to do, firstly in relation to women, which you haven't already done?
I think, well, with regard to trendset, it was more forward-looking than factual now. It's the other one that perhaps may be taken as factual. But anyway, I would say if you come in with those qualities, and if you remember in those very same comments you referred to the GCB first quotes from my article on a feminist approach to the adjudicative process. And it says in so many words, and we will come back to this. And then when they deal with my Buanya judgment, they quote copiously from it. I think it's towards the end, if I'm not mistaken. And then they make the point that now we take you back to the earlier quotation. This judgment shows that he is not just paying lip service to sensitivity on feminist issues. He actually, even in his judgments, does show that this is something that he truly believes in. Now, coming or zooming in on your question, if you come in as a Chief Justice and you actually, as the bar says, you leave this thing, these issues, and it's not lip service to you, I think you will be able to address the issue that you are raising. I think that is what you would be able to bring on the table, at least on that score.
Thank you. Let me give you another example and ask you to deal with it also. The GCB review refers to the other article you wrote on judging according to personal attributes, and refers to you saying that a diversity in the judiciary is important to actually achieve a just outcome, and you yourself explained what you meant earlier. Now, as Chief Justice, if you were to be given that position, how would you cope with the diversity of views and also the need for certainty in law and clear guidance and clear precedent that's easily understood by the legal community and the community at large?
Yes. I'm sorry. I address the issue of diversity in the context of that article to show that there is functional value in diversity. Yes, it is important when this august body complies with section 1742 for all sections of our community to feel represented, to feel that the judiciary is theirs, to own it. So the composition, how it looks, that is important. But in that article, I also emphasize that is now beyond just how does it look. I emphasize the functional value. So here comes diversity and its functional value. Maybe I can best illustrate this. Please forgive me, Acting President. Maybe I can best address this or illustrate this by referring to a judgment by Justice Thurgood Marshall of the United States of America in the matter of KRAS, K-R-A-S, where in ringingly rebuking language fought with, and Justice Thurgood Marshall was African American, I should say that, and the only one on the Supreme Court bench. And the case arose out of something that on the face of it was quite small. It was, if I am to try to understand the American system in a manner that makes sense to me, it was about paying a fee to be able to lodge civil proceedings, which probably would have been the equivalent of the revenue stamps that used to be attached to process in South Africa. Small, modest amount. And Mr. Kras was not able to pay that. This was an issue that was litigated all the way to the Supreme Court of Appeal. And the white justices on
It's a refreshing article, but I need a better, insight.
I think the very fact, in fact, that article, Commissioner Lepu, I don't see the first part, my apology. I've always known you as Commissioner Lepu, my apologies. That article, rather, it was converted to an article from an address I made, having been invited to go address judges at an educational seminar for judges. I converted it to an article. Now, I think it is something that would have to be used. I could do it myself as well, to go to all levels of the judiciary. For example, if you saw, I think about 3, in fact, I think it's even 4 cases on rape, where the most outrageous language is used against the woman survivors of rape. Those 4 cases, I think, were at the magistrate's court level. And of course, there are high court judgments as well. So the very fact that this was raised at the level of speaking to or attempting to educate colleagues, one can take it from there and try to spread it as possible to the rest of our structures within the judiciary. And maybe one could even try to broaden it as much as possible.
I think, Justice Madlanga, a further follow-up on, I think on page 49 of that article, I took the liberty of actually downloading it just to try and understand, because it really excited me. You said the same project has been undertaken in Canada and UK and Australia. Do you think, and you said you wish, one wishes that there should be such a project in South Africa. Do you think it can be followed up, or to try and address these issues of gender-based violence?
It is something that that could and maybe should actually be taken up. To put other commissioners in the picture, what Commissioner Lepu is referring to is what lawyers in the countries that the commissioner refers to do, is they will take a case that raised concerns around issues affecting women as women, a case where a judgment has already been delivered, and that for whatever reasons is just insensitive to gender issues. They will take it and run it sort of as a mock case and even write a judgment, an alternative process of sorts, and then get to the sort of judgment that they think ought to have been delivered in a case of that nature. That is something that could actually play a very vital role in the education process, in addition to whatever processes may be in existence. Taking actual life cases and saying they got it completely wrong. How should it have been done? And doing this in a manner that is gender sensitive, that is...
For you, and they could be seen as follow-ups in a way. The first one relates to the question that Acting President Pete raised with regard to the 2 issues at the Constitutional Court, one being you answered the issues on delay, but Commissioner Dodovu then asked you on the second issue, which was the quality of the judgment of the court. You answered the issue, as I say, on the delays, and on the issue of the quality of the judgment, you said you require details. And I want to give you an opportunity, as Commissioner Nyambi said, you must take up these opportunities and respond to them. With the first one on the delays, you didn't ask for specification. On this one, you did. And I want to believe that you would know whether there are issues or not with regard to quality of judgments. And if you think there are not, it's also okay to say you don't think there are, or if there are, how should we resolve them? That's the first question.
Maybe let me say this. I wrote a judgment which has been roundly criticized. A judgment in the matter of Sita versus Gijima, roundly criticized. Reading the criticisms, there is a lot of substance in them. But of course, I think one of those that wrote the articles went overboard and went to the extent of basically saying, you know, we cannot even think. And I would be surprised if the commissioners sitting here and listening to me speak from the morning can ever have the impression that I cannot think. I would be very, very surprised. But that one academic went so far as to say that. And in fact, it goes so far as to say, we do not even care to think. Is this as a result of Gijima, or is it because of all the judgments that I have written? If that was the case, can people who live closer to what we do, like the organized profession, the BLA has written a glowing report about me. If I couldn't think, I don't think they would have done that. Nadel has written a lengthy comment, glowing, laudatory comment about me. The same with the GCB. They've written, I mean, they itemize, I think they say we're going to discuss each candidate under 9 topics. I think from the beginning, first topic, all the way to the 9th topic, all the things that the GCB says about me are positive. And so, yes, we all do make mistakes. But to then say, those people cannot even think, that's nothing but, just gratuitous insults. I will accept that I do make mistakes, and I will accept that even some of my other colleagues do make mistakes.
Justice Madlanga,
Yes.
may I just correct this? Maybe I may not have come across as clearly.
Yeah.
I didn't understand
Yes.
Acting President Pete's
Okay.
question to be about you personally. It was a general question about the standard.
I understood
quality.
you.
Yes.
I understood you.
Okay.
I understood you perfectly. I just chose to make it about myself because you said, am I not aware perhaps? And I say, I have read academic comment, academic criticism on my judgment in Gijima. And there's a lot of substance. There's a lot of substance in it, So I guess indirectly that answers your question. And I chose to use my own judgment instead of going to other colleagues' judgments.
I guess just to follow up on that.
And I'm not necessarily saying, oh yes, I was wrong, so that colleagues can then come and overrule me. I'm not. All I'm saying, I put it no higher than saying there is a lot of substance in the criticism. Yeah.
Thank you, Justice Madlanga. And I guess the question comes in a context of the position of a Chief Justice who will be responsible for the judiciary. And in relation to criticism of that nature, how do we resolve those issues so that there is certainty in relation to judgments that come from our courts?
I will say, we will never, and not in a single country, we will never reach that level, Commissioner. For as long as we are human beings, we are fallible. And yes, fine, we are an apex court, and then people may say, if even you can be wrong, what then? But we are only human. We are fallible like anybody else. And the world over, in all jurisdictions, one can never be able to say that other courts in other apex courts in other countries never get it wrong. It just does not happen. That's an impossibility.
Thank you, Justice Madlanga. My second and last question, Justice Madlanga. When asked about your experience in leadership, you gave a very lovely summary of what a role of a leader in any institution would be, and you did it twice. The first one was you determine where you want to take institution, and if it's an existing institution, if there are problems, what the solutions would be, and then implement. I would like you, in a way of almost like a closing remark, you would be, were you to be appointed, taking over the role of the judiciary, the head of the Constitutional Court and the chairperson of the JSC. I would like to hear from you, where would you like to take the judiciary, the Constitutional Court, the JSC, just on that summary? What are the priority problems? What would be the solution and how you would implement it? In a summary, I want to be able to leave here and having gotten that from you. And when we deliberate, I'm able to get that, if you don't mind. Thank you, Justice Madam.
Yes. As I said, for me, there is a large elephant in the room, in the Constitutional Court itself, and my vision, and this is important to me because the Constitutional Court is the apex court. My vision is to have a Constitutional Court that is running like a well-oiled machine, finalizing new applications on time, delivering judgments on time in accordance with whatever timeline we will agree to. As I said, I have suggested 5 or 6 months to colleagues. I hope they will accept that, or whatever they settle on. What we agree to should be what we try to live by. Also, I did touch on the delays and not just the Constitutional Court, but the broader context of the judiciary as a whole, trials taking long matters to come to trial, both civil and criminal, and case line, not case lines now, but the case flow management process has made or introduced or brought about great changes in that regard. So one would just have to look more closely at that and see what needs to be done, maybe introduce improvements or whatever else, just to make sure that there are lesser and lesser delays in the process. And of course, there is the question of court online, which is only going to be implemented after the second stage of the pilot project in Gauteng. And a Chief Justice coming in will have to preside over the rollout of that. And also some of the judicial officers are not computer savvy themselves, and they may have a resistance to this notion. And I doubt that just because of COVID, there has been a take up by all judicial officers. One would have to sell the idea. Let me again give a quick example by myself. I was forced by this organization to go online. When I came to JSC meetings, I used to pull a huge suitcase like this. And why I stopped, I used to pay a lot of money. I could not pass on that. I felt guilty. I could not pass that charge to the JSC. I used to pay a lot of money to SAA. Then I was forced to use my computer and to use paper online. So we can easily find ways of making colleagues buy in and for this project to be a success. But one would also have to find ways, as I emphasized earlier, that this is acceptable, accessible rather, to a certain component of our society, but it is inaccessible to other components. One would have to find ways of making sure that it's for them as well. For example, I gave the example of why not take a virtual court closer to the places where people live. Not have a physical structure, no. Within the available resources, for example, have a screen and have people testifying in Protea, but their cases, actually High Court case in Johannesburg. Again, a crass type of case, that is the United States case I referred to. Somebody, an old lady, an old man who lives with grandchildren, and all the income they have is the old age, the social grant. And to say, travel every day to downtown Johannesburg to give evidence every day is quite a toll on somebody like that. Whereas if all that they have to do is go to a court in Protea and listen to proceedings or watch proceedings and even participate in proceedings through a screen set up somewhere closer to where people live. Now, one could come up with a whole lot of innovations to make just truly accessible and to make Section 34, access to court, meaningful for our people, in particular our vulnerable and poor people.
Thank you, Acting President. Thank you, Justice.
Thank you very much, Commissioner.
Thank you, Commissioner Tsepe. Commissioner Matolo Lepo.
So thank you, Justice Madlanga. I think in the morning, I think earlier, you expressed your vision if you were to be appointed as the Chief Justice. And fortunately, one of the things that I wanted to ask you is about you explaining about the access to justice issue, especially the self-representing litigants, but at least I think you have done it just now. But then the other one that I think I need clarity on is the high costs of litigation, especially when we have SCs in this room, you know, and how do you think you can deal with it, you know? And lastly, the use of mediation. I just want a better explanation of the two. What is your vision regarding that?
One can only think about ways of reduction, but not reduction of council's fees. I cannot see how I can possibly, all commissioners will probably see the direction in which I'm looking. One cannot even begin to think about saying to council, please don't charge X amount of money. I think it would more be, you know, their clients who would have a clout in that regard. What could happen is rather more, you know, issues that could cut down on costs. Like, for example, I think the very idea now of hearings that on a relatively large scale have taken place online should in itself cut down on costs. I said I traveled all over the country, my practice. Imagine the disbursements from the traveling costs, the hotel costs, and maybe you are sometimes there for a whole week. All of that gets passed on to the poor litigant. But now, counsel, one will be in Cape Town, another one in Durban, and so on. There will be no such disbursements. So maybe there is a need for, as part of this the revamping the systems and pushing for an online system that will redound, hopefully, to the benefit of the ordinary person in the street. But of course, as I said, there's always the problem of accessibility and so on and so on. But maybe with a serious application of the mind, solutions can be found. I did give the example of the one possible solution that I gave. But the very idea, you cut out the disbursements, and you are basically left with the legal fees, consultation fees, fees for arguing in court, and so on. And those disbursements are not an insignificant amount.
I think the second one is the use of mediation. I think you said it should exclude judges, if I'm not wrong. Just how do you say it?
The point I was making was more that if it is used more and used effectively, matters that do not really have to be litigated, the process may hopefully have the effect of taking them out of our system and therefore assisting the courts to focus better on those matters that truly have to be litigated. That would be the benefit to the court system. And my understanding from the article that I referred to, penned by Deputy Judge President Roland Sutherland, is that this is not used optimally at the moment.
Okay, thank you, Acting Judge President.
Thank you, Commissioner Matolo Lepu. Justice Madlanga.
I'm very sorry. I whispered something. I was saying. I would.
I heard you, Justice
me.
Madlanga. So I think
I
maybe.
I hope this will not be a meme. Oh my God.
Perhaps we should then take just a 5 minutes comfort break.
Thank you very much.
Thank you. Fellow commissioners, will you please resume your seats? We are still left with about 11 members of the commissions. I would appeal to the remaining commissioners to try and adhere to their allocated time. And once more, Justice Madlanga, please keep your answers short.
Thank you, President.
Thank you. Commissioner Shabangu Mdawe.
Thank you, Acting President. Good afternoon, Justice Madlanga.
Good afternoon, Commissioner.
Justice, I think 98% of my questions have been covered by the fellow commissioners.
Thank you.
But I only have two that I want clarity on. Access to justice, it's very close to my heart. From what you have already alluded at, do you have any idea as to how can you improve on that so that even a woman who is somewhere in Buzini or Kamhlabuhlangene can be able to access justice? Someone who doesn't even have a screen, the one that you have made example on, as to how can they access justice on. Can I also just throw in the second one so that you can be able to answer it as one, so not to waste time? There's a concern from the GPV activists. You spoke about sexual offenses. The concern is that the cases on sexual offenses took time or take time to be heard in courts, be it lower courts and high courts. How can you, as the Chief Justice, assist that those cases are speedily heard so that they can give closure to the victims? Thank you.
Thank you very much, Commissioner. You refer to a person from an area that I think is like my own rural area. I'm born and raised in a rural village outside or some kilometers out of a rural town. And you instance a situation where this person does not have a screen, and you are referring to my example. My example was attempting to make the point that the screen should not be that of the person concerned. The idea was more that that person you are referring to, because sometimes there can be really long distances between, say, for example, the area you are referring to and the seat of the court. Say, for example, it's a high court. There are usually even longer distances there. At least with district courts, there will be a district court in the town where the person lives, even if they live in a rural area outside of the town itself. So for that person to travel all the way from some rural area outside of Pietermaritzburg, so my idea of the screen was that the screens which are not or should not belong to the people, but the screens be brought closer to where the people are at state expense. But of course, you and I know that the idea of resources, especially now, will be thrown back at us. But the idea, that is what the idea is. And Commissioner Singh said, if something must be done to make sure that our judicial system works, funds just must be found somewhere. And one hopes that, because it is Parliament that votes funds, so one hopes that, with ideas like those and parliamentarians speaking as parliamentarians and pushing each other, the resources can somehow be found. If that will materialize, I do not know. I will not lie and say that I am, at the moment as I sit here, know whether there are specialized courts that deal with sexual violence or offenses involving sexual violence. But an idea that I have, in case there are no such courts, there is no reason why, just in the same way that in the big centers you have a specialized commercial court, there is no reason why you cannot have specialized criminal courts that deal cases of this nature. And the hope, of course, being that there will have been no hold-ups at the investigative stage, and then once a matter lands in the hands of the specialized sexual offenses court, it gets dealt with expeditiously. And the advantage of that also would be, once the court is a specialized court, there is going to be, or rather, expertise is going to grow within that court, and that will add to its efficiencies.
Thank you, Justice. Thank you,
Thank you, Commissioner.
President.
Thank you, Commissioner Shabangu Ndawe. Professor Schlemmer.
Thank you, Acting President. Justice Madlanga, when you spoke about your vision, you indicated that you are concerned about the commercial cases that go on arbitration. You answered questions on the quality of the judgment of the Constitutional Court. And you read the news, you would have realized and remembered also that during the interviews last year in April, that we spoke a lot, or maybe I did, a lot about the scholarliness of judgments, and the reasons for that was eventually also indicated as a lack of funding due to the fact that researchers cannot be appointed to all the high courts, or enough researchers. So all of this leads to the one question that I have, and that is that there seems to be a problem concerning some of the judgments and the quality of some of the judgments. How do you foresee, if you were to be appointed as the Chief Justice, to address these matters? Not only in the Constitutional Court, but more, because I think the issue is way, way broader than at the Constitutional Court.
Yes. It is a great pity that I will want to take this, not just one, but many steps back. Judicial education, without in any way expressing a vote of no confidence in it, by no means, because if I did not have confidence in the process, I would not myself have participated in it. I gave the example of participating in seminars at judicial education. But judicial education can only do so much. If you have not been exposed to a very large extent during practice to various areas of the law. Yes, I did say, and I will not contradict myself, that if you apply yourself seriously enough, even at the level of the judiciary, it is possible, it is quite possible to catch up and reach a level at which you can deliver judgments that are at an acceptable level. But it may take time for you to reach that level. And going to a seminar over 1 week cannot really have the same effect that growing up as a practitioner that is exposed to sufficient work. You cannot grow with those 1 week there, 1 week there. You will not grow in the same way that you would have grown as a practitioner. When you have grown as a practitioner and you have the right level of experience, you, to use the hackneyed term, you hit the ground running, as it were, and you are able to do everything. But as I say, I want to emphasize, I'm not going back on the point I made earlier. So this goes back to an issue that in some ways may be outside of the hands of the Chief Justice, the briefing patterns, which is a systemic, perennial problem. We need to have our people exposed to work at the right point, which is practice. There are various stakeholders. I touched on that, and I said that to the extent that I may be able to, I am quite willing to also play a role and engage all the role players in that regard. Let people grow at the level of practice. That's the best way you can cut your teeth, and by the time you get to the bench, you are ready. That would go some way towards eliminating some of the problems that you refer to, Commissioner.
I agree 100% with you. And on that note, if you had a choice to change the way in which judges are appointed, what would you do?
That's a very difficult one, Professor. I think, as I did in response to another question from one of the commissioners that side, it's something that I would, if appointed, it's something that I would have to apply my mind to. One, would that be necessary? And if it is necessary, what route should we go? I will not pretend that it's something that I have thought of. I have not.
The reason why I'm asking this question is one often hears that people say that the JSC does not always have the interest of the judiciary in mind or properly in mind when recommendations are made for the appointment of judges. What is your take on that?
When I sat here, I thought we did, and you will recall earlier I said I hardly ever watch the proceedings. It would be just glimpses here and glimpses there of what happens during the processes here. So it's very difficult not having seen how candidates before you perform for me to be able to say, nah, they should have taken candidate A instead of candidate B. That's very difficult for me to say. But I am willing to say, when I was part of this body, I believe we did. And by saying that, by saying at the time I said here we did, that is not at all a pronouncement that at the moment the JSC is not necessarily doing that. A lot does turn on what happens here. Because sometimes you may know somebody to be a very good lawyer in terms of forensic skills and so on and so on. But once people come here, a lot more gets asked about, issues that are considered to be relevant, and the people may come short on some of those things. And because I never, as I say, except for short glimpses, watch what happens, what questions people get asked, it's difficult for me to pass judgment.
Thank you. Thank you, Chief.
Thank you very much, Professor Slema.
Thank you, Professor Slema. Commissioner Nogesi.
Thank you, Acting President. Good afternoon, Judge Madlanga.
Good afternoon, Commissioner Nogesi.
I just want to start on the very point that everybody have asked you about, this issue of leadership. In Umtata, in the Transkei division, as it was then called, you presided over 6 judges. In fact, you were the 6 judges. There were 5, you were the 6th judge there when you were the acting president in that division. And you outline what you have to do as the acting judge president of the division. That's what you just shared with us.
Oh, I saying I should share.
Yeah, that's what you just shared with us.
Yes,
what
yes.
it is that you have to do as the acting president of that division.
Yes.
But this is what, to me, is more important, which you don't share.
Yes.
You became the judge in 1996. That is your first appointment.
Yes.
It is at the time when there's a tension. There are few black, you were one of the first few black judges that are appointed into the bench. And if you calculate from that 96 to the time when you are appointed as the acting judge president, that experience is what we would like you to share with us, because we would like to see how you integrated into the new system, where you bring all these judges together, how that enhance your leadership as a judge, as a leader.
As a leader. I must say that I came in the footsteps of Judge President Somialo.
Yes.
And so I think by the time that I came in, the court was an integrated court, and the relations were good amongst all colleagues. In fact, I think we were quite fortunate, even when I came in and the leadership was still a white colleague, Judge President Beck. If I could use the term, he in fact had literally used this unusual term. In a sense, one could say he had headhunted me, as it were. And relations were quite cordial. So to come closer to what you're asking, everything ran smoothly, and it was easy for me to bring in whatever innovations I wanted to bring in. Everything was accepted easily.
Yes. In the period just before 1994, that is before the elections, first elections, when you have no black judges, what is clear to me is that black people in particular, and to be specific, practitioners such as yourself, have a decision to make. That is, is we are either on the side of the people, that is the black, the oppressed majority in the country, the black people, or for convenience, for your own convenience, you are part of the oppressive system. And from the list of people that we work with, Square, Muerane, all those, that were resisting the system, to me, how would you not categorize such decisions as leadership on their own? Because we had a choice to simply say, oh, well, I'm a lawyer, I can just concentrate on my leadership. But now you make a conscious decision to say, I align with the oppressed people, and it was not fashionable at the time. You were very few to take such decisions.
Yes.
How you jump that you don't count as part of your leadership?
Yes, I guess I came in at a time when the sort of cases they did, were towards the tail end, but I did get involved in a few. For example, I'm sure you know because he's your homeboy, Leonidas, commonly known as Leo Katula, who was killed by security operatives close to years. I represented his family when they instituted a dependence claim against the government. Also, there is the well-known case of the children of Mr. Bendulo.
Yes.
The children of Mr. Bendulo who were gunned down at Northcrest in Mthatha, again by security operatives. And the floor was just all blood throughout. There as well, I represented the Bendulo family, briefed by Ubudumisa Tsebeza. You know how strong he is, but when we consulted, Ubudumisa was almost in tears. So even though I came in at the tail end, I did get involved in those sort of cases.
Yes. Now, I see from your CV,
although, of course, I never went to the stage of the trial, but I drafted the particulars of claim in the Bendulo case.
Yeah. I see in your CV, as part of your reference, this is what you write. You write, your first reference is former Chief Justice P.N. Langa, former Chief Justice of South Africa, and then this is what you write. Although he has since departed, I cannot bring myself to delete him. Call me sentimental. Can you explain why you felt it important that you make reference or you include as one of your reference Chief Justice, former Chief Justice Baslan?
I am in the comfortable position that the references are never used, but even if they were, I doubt that I would remove Ikamalga Butpayas from there. That is, or to translate, that I would remove Butpayas's name from there. I think, don't I have 3 references?
Yeah, you do.
I could live with the 2, but still keep his name on there. Dandimtand. Dandimtand. I was close to the man. I liked him. And I just, as I say there, I just could not bring myself to deal. Once he passed on, because I put him on there even before he became Chief Justice. And he has stayed on my CV forever. And I will keep his name on there until I die.
Just to me, this is very important. You mentioned when you deal with some other...
And maybe, if I could add, the circumstances in which I met him were actually the same context that you referred to, and I quoted these other 2 cases. It's just that I forget the case name in this one, but that too was a security-related matter in which he and I were representing 2 witnesses. He was representing his own witness, and I was representing a witness. The so-called recalcitrant witnesses witnesses who would not testify, and therefore you as an advocate would have a watching brief. That's where he and I first met, and then we continued interacting thereafter.
Yeah. I want to believe, correct me if I'm wrong, that since 1994, amongst the present justices, not only in the Constitutional Court currently, even some, but correct me where you're wrong, I'm wrong, you are one of the few that have worked with Ismail Mohammed, worked with Pius Langa, worked with Arthur Chaklason, worked with all these chief justices. You can just tell us which of the chief justices that you have not worked with, but as I understand, you have worked with all of them.
Yes.
And when you answer that question, could that be divorced to succession planning, exposure, understanding where we're coming from, the approach in terms of setting up this new constitutional dispensation?
I would say the exposure to several and different leaders at that level certainly does add something to one's own outlook on the leadership of the judiciary.
Yes. I'm sure I'm left with 2 minutes out of my minutes I checked. The point I would like also to draw your attention to is, in fact, we have dealt with this question. I must go to the next question. This issue of judges calling for press conferences to answer matters that they find objectionable. Perhaps if you don't feel comfortable with that question, because I think I will deal with other candidates, you can tell, you can say so. But my point is, the calling of press conferences by judges to respond to political rhetorics and statements which they perceive to be attacks and criticism, how would you respond to it, if you can?
I attempted, Commissioner, to deal fairly at length with I guess you are teasing out just the question of a press conference now specifically. I think I actually did allude to that question when I said, yes, the one approach could be the one of approaching the two leaders of the two arms of state, approaching each other and talking. And then I said, on some learning that I have had the advantage of going through, a point is made, and I think I do share it, a point is made that there may be times when somebody who is at a certain level within the judiciary, and that for me speaks to the leader of the judiciary, may have to respond. Take a situation, for example, where you try to reach out to the leader of the other arm of state, and you see that things are going exactly the way that Justice Mohammed says that shouldn't go, exactly the way that Justice Correctional in Mamabulo warns against. And then you try to reach out to the leader of the other arm of state, and you are met with resistance, or the leader just says, I will not see you at all. Or if they see you, they say, there's nothing I'm going to do about that. What do? Do you then throw your hands up in the air and do nothing and let the public believe whatever they want to believe in an instance where something does have to be done? But I want to emphasize, and I did say this before, I am by no means advocating a situation where day in and day out we would be running to the media, not at all. But there will be, and it is quite conceivable, there will be the odd occasions when that may be necessary.
This is my last question now. The question is only on this.
You have exceeded your
But
time
to-
allocation by 10 minutes already.
It's just that I thought it's only the 10th minute now. Can I, with your leave, just ask you
Please,
this
please
question?
pose your
It's the last
question, Commissioner
Thank
Nkesi.
thank you, President. Thank you. I just want this question because this question on transformation has been asked by everyone. Would you agree with me that in this country, banks and big business, they are advocating for racism. They hate black practitioners. Would I be correct to make that conclusion that big banks, business, actually advocate for racism? Because they are the people who don't want to brief black practitioners and women in all their cases. You can take from at the SCA Constitutional Court, if the case that involves them, they simply don't brief black practitioners and black women. Is that not racism, or how best we can describe it?
Commissioner Nkesi, the reality is that I did say, take Mthatha for example. There are banks there as well. There were banks, and I think the only bank that briefed black people was on York Road. Yes, TNBS, and then the big banks did not. So the reality is that whatever tag you want to give it, they obviously prefer to take the work, to take their money to people who look like them. And look like them, that is who owns the banks. That is the reality of our situation. And it explains why. Yes, there was a little bit of commercial work in Mthatha. It explains why I was never exposed to that. And it can only be on the basis that those who have the money, and preponderantly in South Africa, it is white people. Those who have the money will take their money to their own people.
Thank you very much, Chairperson.
Largely. Yeah.
Thank you, Commissioner Nkesi. Commissioner Klaba.
Thank you very much, Acting President, and good afternoon, Justice Madlanga.
Good afternoon, Commissioner.
I just want to go back to the question that Judge President Taletsi raised earlier on, and also touched on by my colleague who just came before me. But I want to broaden it. It's the traditional approach to the traditional approach that says that judges speak through their judgments. In the context where there is now a temptation by some within the judiciary to contribute to the ongoing debates under the rubric of freedom of speech. And what is your take on that?
Commissioner, I have attempted to deal with that one at length at the beginning, and I think there was also a follow-up question on it. I'm not trying to duck it. And then again, Commissioner Jesse engaged me quite extensively on it. I don't think I have anything to add, really.
With due respect, Justice, I thought that was confined only to press statements.
Oh,
Press statements. I'm just talking generally.
Yes.
The principle that judges speak through their judgments and the temptation of senior judges to contribute to the issues of the day.
Yeah. I hear you now, Commissioner. My apologies. To that one, I would say, Commissioner, the issues that I say may actually call for a response from the judiciary, and on which I said the approach or possible approaches are two-pronged. Sometimes do not relate to court-going matters. So there will be, at times, there will be no judgment to speak through, as it were. Yes, sometimes criticism may come up as a result of a judgment that we may have given. And in those instances, I do not see why a judge would want to go speak and try to say, no, actually, this is what I meant and why, because it's in the judgment itself. But there are those instances where the criticisms, the minister added attack or attacks
not just
may be relating to issues that have nothing to do with judgments.
Sorry,
yes.
just to assist Justice.
Yeah.
I'm just talking it in general. Please don't confine it to the attacks. Is judges wanting, judges entering into a political discussion to an extent, in some cases, of contradicting government policy or policy of the country?
May I think now I get the idea, I get an idea of what you are probably alluding to. May I ask to duck that question and put it no higher than the level of principle, which I think I have already addressed, because you'll correct me if I'm wrong, because what I think you are alluding to is something that I think is a litigious matter. And as a sitting judge, I would prefer not to speak to it. So I am quite comfortable addressing issues in general terms, and I think I have tried the best I can to do that. But let me say this. The code of conduct, and I thought I did touch on this earlier, when was it Justice Khaletse was asking me. The code of conduct does say judges should not involve themselves in political controversies. The code of conduct does say that. And you will remember, Commissioner, that is when I then made the lengthy attempt at explaining how we nonetheless will still get involved in political issues, but in the process of the adjudicative process. And then I did say that But once you stray outside of the adjudicative process and meddle in political matters, that's when you may then transgress the code of conduct. I did say that. I am willing to stand by that. That I will not duck. But it was more a feeling that you may be alluding to something specific, and which is something litigious that I say perhaps it's I hope at least at the level of principle, yes, we should not meddle in political controversy. I say that categorically.
Thank you very much, Judge,
yes.
you've answered me. You are selling us a vision, and you further state that the period remaining in the bench does not count against you being appointed to the position for which you have applied, the position of Chief Justice. Now, don't you think that the short term will make your vision a nearly impossible feat, and two, may not contribute much to the stability of the court? I'm sorry that I have to belabor the point, but I thought I should raise this as a parting shot, because it will exercise the minds of the commissioners. Thank you.
Thank you, Commissioner. I will also, in a sense, be belaboring my response. I gave the example of me acting as a judge president for, I think, was it about a year? And within that year, bringing in innovations, and I gave you a tangible example of what I came up with tangible results, a year. I also gave the example of somebody that is well known to this august body. I'm sure, if I sat down, scratched my head hard enough, I could easily come up with more. And I gave the example of Judge President Benenge, who within a year was able, I will not say that the Eastern Cape Division was a horribly performing court, no, but he took it from whatever level it was at and took it high up to one of the better performing divisions in the country, again within a year. And I think some of the results of that are quite visible even to this august body. And I hope I will not cause resistance for him in future when he comes here, because he and I are quite close, and I do know that by and large, he even manages in this august body to one, he is able, because of how he can identify talent, or of course it's the minister who makes the appointments, recommend appointments, and then have people acting. He is able to bring to this august body the sort of talent that by and large this august body has found acceptable. But that's just one facet. Overall, he has made that division one of the better performing divisions, and he did that within a year. So 3 years, I repeat categorically, Commissioner, 3 years is a very long time. The entity that I said I ran, and I quoted from you the very laudatory, the very praiseworthy words by Deputy Minister Jabu Muleketi about how I led that entity. That was what? It was around 3 years. Starting it from an empty floor. 3 years, I repeat. And if I could rattle off the figures, we are talking tens and tens of billions of rand that were exposed to the country, increased the tax base, and so on and so on, within a few years. Now, let me quickly, please forgive me, Acting President, let me also say something that I think, without at all suggesting that people who have longer terms, for example, colleagues coming in would have 12 years as Chief Justice. If at the level of principle or policy, whatever tag may be given to it, it were ever to be said, for somebody to be appointed Chief Justice when they are left with only 3 years, 6 months, at the level of principle, that should not be done. That would send a very bad message. It would mean that senior judges at the Constitutional Court should forget about ever becoming Chief Justice. Somebody coming in having 12 years, even people who would come in, say, 2-3 years after the Chief Justice who has 12 years, and then that Chief Justice leaves, those people would be the most senior at the court when the Chief Justice leaves, the Chief Justice who was there for 12 years. They will be the most senior, and they will be in exactly the position in which I am here today, and they will be told that you are left with only 3 years, forget about ever becoming Chief Justice. That would send a bad, bad message. By saying that, I should not be misunderstood. I am not saying that somebody should not be appointed from another court, and if they are of a young age and therefore can serve the 12 years, should not come in and serve the 12 years as Chief Justice. I am not saying that. All that I am arguing against is an idea that 3 years, 6 months is all that is left for you, forget about it. That will send out a very terrible message.
No, you have answered me. Thank you so much.
Thank you, Commissioner Taba.
Follow up.
Justice Madlanga,
Follow up on that.
I'll defer to you, otherwise I had a follow-up.
Okay. No, it's just on that point. I hear Justice Madlanga, you are emphasizing 3 years, but I'll want to read that you don't really mean 3 years. You mean that 6 months, 2 days, 2 years. It doesn't matter. 1 year, yeah.
No. Let's focus on my 3 years, 6 months, Minister, please.
Okay, that's fine.
Thank you.
Justice Madlanga, as a follow-up, I think at least you would accept that, some of the changes or innovations you might wish to introduce, especially, changes which are momentous, would have to go through, long pipelines because, to get to fruition, because you would, for example, need to get a buy-in from across the board. Would you accept that as a general proposition?
I would say that could easily apply to 4 years, which Chief Justice Langa served. What's the difference? What much difference is there, Acting President, between 3 years, 6 months, and 4 years? The difference is only 6 months, and there was no problem at all with the Chief Justice Langa becoming Chief Justice. But addressing the point of substance, those problems that you allude to would really have to be close to insurmountable problems for them to take 3 years, 6 months to resolve. Then I think that perhaps would more be a function of them not being seen as acceptable than a case of finality being reached on them.
I hear you, except that former Chief Justice Langa was the only candidate when he was interviewed by the Judicial Service Commission.
But my point stands. My point stands, though. My point stands because the person who does the appointment should have said 4 years is a very short period. Somebody does the appointment. And if this is a factor, it should be a factor at all levels, not just with the JSC. It should be a factor with the person who does the appointment as well.
Thank you, Justice Madlanga.
Thank you very much,
Commissioner
Acting
Mpofu.
President.
Thank you, Acting President. Just another follow-up. Justice Madlanga, I would like you to answer this question more on this issue of the term. Just as the issue of leadership earlier, which, as you correctly pointed out, was raised in the media as a drawback, which you've really dealt with effectively, I think. This is also a question of a similar nature. And I think you should take cue from the last remark of the acting president. I said earlier to you that although you are all senior judges and you are all collegial and all that, but bottom line, this is a competition, right? So this time it's a competition. It's not just one judge sitting there as it usually is. There are other candidates, and you must accept that when we ask you questions, we are mindful of the fact that there are other candidates.
Yes,
and it's an opportunity for you to allay any fears that might be there. Let me try and explain it to you. It might well be that actually this is a neutral factor. But the reality is that some of the candidates will be able to serve for a longer period than you would if you were appointed. Yes. It's a fact.
Yes,
and I think what the commissioners are trying to do is to give you an opportunity to convince us that when we do deliberate, we should not overemphasize this factor as a disadvantage in your case, just as we should not overemphasize the fact that you have not had an opportunity to lead a court permanently for a long time or for as long a time as the other candidates. So, I would like you to deal with it frontally and explain to us why, for example, my own instinct would say, oh, well, if you're only left, let's use the minister's example, with 18 months. That means in 18 months' time, we must go through this again, just, as a country, of selecting a Chief Justice. On the other hand, it might well be that if we have somebody who's going to serve for 10, 12 years, let's say in the first 6 months we realize that we made a mistake, then we're stuck with that person. So it's a serious matter that must be confronted. It's a reality. And we need to be convinced that it is not something that should be a game changer.
I thank you, Commissioner Mpofu. I did not want to touch on the point you made towards the end. I did not want to make that point myself because it would sound quite negative. But as you say, these two, aside of the idea that I lack leadership, these two is out there in the public domain, but he's left only, the 6 months is not even added, he's left only with 3 years.
Sometimes it's even said 2.
So Commissioner, I did think exactly what you just articulated now, and there was no way I could articulate it. And I thought, but what if, the person who will serve 12 years then does not prove to be what you wanted? But I'm not at all. This is not at all casting
You're not
any
saying it.
aspersions against my colleagues, all of whom I respect, not at all. But Commissioner Mpofu, I may be repeating myself, but I want to say that I took the question with a seriousness that I believe it deserves. It may at that time not have been raised, or in fact, I mentioned, my idea of the qualities of a leader in a different context. In fact, when I was exactly dealing with my leadership skills, I actually have those points on leadership skills. I have them under a flag here that says term. And I make the point that what a leader needs, again I say I'm repeating myself, but this is to show that I am taking it with a seriousness that you quite correctly say, I should address it with. I say, I disagree that the term is short. Leadership requires a visionary, someone who can identify A, where an institution needs to be taken, B, problems, and be able to come up with solutions, and then implement immediately. But of course, as the acting president correctly points out, implementation may be impacted upon by the responses that you get. But for that to go to 3 years, my mind says that should be in respect of what perhaps may be found to be unacceptable. So if you have those qualities, you should be able, within a matter of days, months perhaps, and to the extent that I said if I am appointed, I will approach other heads of courts from the Supreme Court of Appeal to the district court, get ideas from them as well. Once I have solicited or obtained all of that, reached decisions at the level of heads of courts, I will push for implementation immediately. This is all of this, Commissioner Mpofu, is something that can happen within a relatively short time. And if what you have identified under my A and B is something momentous, something concrete, and you are able to then create templates on it, that should leave that should leave the judiciary with lasting templates to be used into the future, even by your successors. What is crucial is that initial stage, that identification process, both of where you want to go and also what problems do you identify and how do you solve them. That is the crucial stage. And then immediate implementation, immediate being relative in the sense that who do you have to consult with. And those in my book do not require years and years and years. I hope I have answered you, Commissioner.
You have, thank you. Thank you very much, Acting President, for the follow-up.
Thank you very much. Thank you.
Thank you,
Commissioner.
Thank you,
Commissioner Mbofu.
Justice Machis.
Commissioner Mapisang.
No, I want to make a follow-up.
Oh, I'm sorry, Commissioner
because,
Malema. Yes, you may
Justice
proceed.
Madlanga, you said something about the person who appoint would have made a consideration about 3 years and 6 months. I don't understand that comment. What do you mean by that?
Oh, no, I was not talking about my 3 years, 6 months. I made that point, Commissioner, in the context of it being put to me that I'm sorry. Justice Langa was the only candidate. So yes. Then I said yes. Even so, if the aspect of the length of the term is such a crucial aspect, then it should have been something that should be on the table, even at that level. That is what I meant.
But Commissioner Mbofu makes a point that we may appoint someone who has 12 years to go.
Yes.
And in 3 months' time, we realize this person was a terrible mistake. An impression wants to be created here that we are going to put our hands on our head. Is that not wrong? Because if we realize in 3 months' time, 6 months' time, 1 year's time, 5 years' time, that we have appointed the wrong person, I don't know what's the wrong person. Are there no institutional mechanism to self-correct?
Thinking of the CAF, Commissioner Malema, you would probably have seen in the Judicial Service Act under the disciplinary processes there that it is not everything that can lead to getting rid of a judicial officer. So I think it is at that level, perhaps, that Commissioner Mpofu would be raising this. At the level of leadership, sometimes you may not reach a point where you say, we must, short of for a voting process, for example, you may not be able to reach a level at which you say, let us get rid of that judge. And you know how in South Africa and in most countries, I believe, you get rid of judges is through an impeachment process. So there may be certain shortcomings with regard to the level of leadership, which may fall far short of getting to that sort of level.
No, I agree, Justice. All I want is South Africans to be assured whether those things get to be applied or not is something else. But in our judiciary, if a terrible mistake has been committed in the appointment of the judge, there are institutional mechanisms to correct that. It's not a hopeless situation that we are stuck for 12 years, as if there is no mechanism. Because I earlier said, I don't know what will be such a terrible mistake that will all be like in 6 months. This was a horrible mistake. I don't know, I'm trying to imagine that, but if that happens, there are institutional mechanisms to self-correct. Like you said, they might take long or all of that, it's okay, but we agree that there are institutional mechanisms where we can intervene if there is a terrible mistake with a judge appointed by this August House.
Yeah, yes, Commissioner, it is this body that is, besides the recommendations that it makes in terms of the Constitution, it is also the body that is also tasked with advising on matters that pertain to the judiciary. I guess in that context, it may maybe raise certain issues with the judiciary as a body, because a Chief Justice is not the judiciary as a whole. So if an issue is about the judiciary, then this body may raise that with the judiciary as a collective, exactly on the basis that aside of recommendations on appointments, it also has the mandate to advise on issues pertaining to the judiciary. Of course, if the shortcomings are of a nature that falls within what the Chief Justice may have to be disciplined on or about, then that has to be done as well.
No, all I'm saying is that let me talk about a Chief Justice. If a Chief Justice becomes a horrible mistake, like we once had with some judge there in Pretoria who said it's still to see a black woman who's not raped by their uncles or something like that. A Chief Justice, immediately after this, he says something like that. At the despite still having 12 years, at the institutional mechanism to hold that Chief Justice accountable and decisive action taken against that Chief Justice, or will be stuck with a Chief Justice who view black African women in a manner I described earlier on?
No, Commissioner, you do not have to be. The Commission and the country does not have to be stuck with somebody like that, especially somebody, with transgressions at the sort of level that you give, or it may not be transgressions of that nature, but comparable transgressions. The Act is there. The Constitution provides for impeachment, and at a certain level, that judicial officer, including a Chief Justice, may have to be or would have to be impeached. They are not above, one, the Constitution that provides for impeachment, and two, the actual processes that are provided for in the Judicial Commission Service Act. A Chief Justice is not above those processes.
Now, here we've got a candidate of 12 years, well qualified, well articulated. Okay, let me leave it. I will take it on my 10.
Thank you.
I thought this was it, Commissioner Malema.
Thank you, Commissioner Malema. Commissioner Mapisa Ngakula.
Thank you very much, Acting President, and thank you, Justice Madlanga.
Thank you, Commissioner.
Justice Madlanga, somewhere in your questionnaire, I read the questionnaire which you were provided with, where you provided answers to the Commission. I read in question number 18, your response, which says, the question was, what would you regard as your most significant contribution to the law and the pursuit of justice in South Africa? And your response to that was, and I won't read it, but I'll just cite what you are saying there. Amongst others, you are saying law does not coincide with justice. And, okay, you're now talking to a peasant, somebody who's very raw. And there are many others who will come across your questionnaire and read what you have, how you have responded to the issues raised there. Then you go on to say, you use your instinct for what is just. And your instinct motivates you in the exercise of judicial function. Okay. Just clarify that to us ordinary South Africans.
Yes. Thank you, Commissioner. There's a nuance, Commissioner, on the first part of what you said. You said the law does not coincide with justice. If I say so there, then I made a mistake and left out a word. What I think I said, and if I've not said it, what I meant to say was that law does not always coincide with justice. And then the point I am making about a natural instinct within me, and which I believe guides me in the adjudicative process, is an instinct that I feel is motivated by an innate sense of justice within me. And I believe that that assists me in those instances where law may not coincide with justice. Not just, I will again use my self-created adjective and say, throw up my hands in a Palatian manner and say, that is what the law is. Yes, it is unjust, but because that is what the law is, I am not going to do anything about it. That innate instinct for justice motivates me to say, is all that we can do in these circumstances, why is this piece of law like this? Should it be like this? I will give a live example, a judgment I wrote in the matter of Mukoni. Somebody, I think in Springs, running a small business in town, and she has a lease. And the term for extension comes, and the owner of the shop where she's running this business writes on this contract as it is across the face at the top, extended for whatever the period of extension was. And the lease agreement had what is called an option to buy. Now, but then the owner sold to somebody else. When she, Ms. Mukoni, tried to hold the owner to, and these were companies, the seller, owner, and the other company. When she says, no, I want to hold you to this because there is an option here, then they said there is an old law. No, they didn't even say old law. There is a legal principle that says, if there is no specific indication that you are also extending terms of a contract that are not essential terms of a lease agreement, those other or additional terms like an option would be, an option to purchase would be additional. Those additional terms that are not integral to a contract of lease do not get extended. My instinctive reaction to that was, it sounds like there's something wrong altogether in this. And I was allocated the judgment in that matter, I sat down, dug down, and I found a 1904, if I'm not mistaken, somewhere there, case. You'll know that some law we get from the Roman Dutch law, from English law, and so on, and it makes up what is called our common law. I found that 1904 case that we imported into South Africa, and that has been followed for all this time. But when I interrogated the judgment, I just did not find the principle enunciated there convincing at all. Because it just said, sort of as a matter of legal principle, this is what it should be. And I said, no. This is a contract. And with all contracts, you must interpret a contract. And that is what should determine the outcome. Not a position that is predetermined and which, in my view, is against the ordinary rules of how we deal with contracts. And I upset that old 1904 English legal principle. So the short point I'm making is, I was motivated by, no, this just does not sound right. This just does not sound just. I hope it explains the point.
And thank you very much.
But what I must clarify though is, I should not be understood to be saying that just because of this instinct, I will always, and at all cost, try to find a way of getting around what the law says no. There will be those instances where the law is unjust and there is simply nothing I can do about it, unfortunately.
That's a very interesting one, because actually I think maybe at some point you need to educate us. Now you are saying sometimes the law can be unjust. If the law is unjust, what do you do? It's a discussion for another day.
Yes.
Because at the end of it is that sometimes we become critical of some of the decisions you take.
Yes.
And when we are critical of your decisions, sometimes it is because we feel that the judgments are unjust. And it could be instances such as the one you've just mentioned, that sometimes the law is unjust.
Yes.
Now, the other thing I wanted just to raise is, it's not a question, it's just to caution. That same question, 16.3 and 16.4, I noticed that both of them, you responded in this manner. You say your memory fails you. My memory fails me, but the one case which I can remember, in the first one, which is 16.3, you cite the case you remember, which is Ndambo versus Minister of Safety and Security. And then 16.4, you cite
Quetta. Yes.
I think if there were cases which were going to be mentioned, such as the ones you have mentioned, I personally would have preferred that you do not even say that, because that, the question doesn't say you should list all the questions. Once you have cited the one
that
in my
I
view,
remember.
Yes, I think that is enough. I think it talks to the matter which was raised earlier on. You are here, whether you like it or not, to market yourself. And when we deliberate at the end of everything, we should be able to say, well, in this questionnaire, 16.3 is responded to in this particular manner. I would have definitely, I don't appreciate that you actually wrote that. Your memory
I
failed.
forget, does the question say that I remember?
It says, please list cases in which you gave judgment that were unsuccessfully appealed against, not more than 10.
I actually think, Commissioner, that even on another occasion, I would still answer that question that way. Because if I were just to say Quetta on the one, and then the other one on the other, what if, take what the GCP has done, for example, the extensive exercise it has done, dug into all judgments, Then I just say Quetta on the one question and that one, and then they dig up and say, look at what he's saying, this person is dishonest. We've come up with other decisions where his judgments were upset, and yet he has not listed them. He wants to give the impression that this is all that was ever upset by an appellate court. So I was a judge at high court level it's as good as the 90s, because after that I acted in the Supreme Court of Appeal, the Constitutional Court, and then very shortly also back in Mthatha for a very short period. Then I went back to practice, and then I came to sit at the Apex Court. So it would have been, that very limited time, years and years ago, that the possibility of my judgments being upset on appeal would have been a factor at all. Now that I sit at the Apex Court, no court can upset our judgments. So for me to be categorical, with regard to years and years gone by, it would actually have been an error, Commissioner. So on any other day, I would still respond to that question exactly the way I have.
Well,
I
thank you.
I hope I'm clarifying.
I've understood, yes.
Yes.
I do want to, I know my time is up now. Justice Madlanga, would you say South Africa is ready for a Chief Justice who's a woman now? I'm purely raising this, and I know this is a very sensitive matter, very difficult.
Yes.
I'm looking at the list of Chief Justices we've had, Chakalsin Langa Ngobo and Judge Mogoeng, and we are now post our democracy into our 5th Chief Justice. And I would want to raise this. Would you say South Africa is ready? And I want your honest answer to it. Thank you.
Thank you, Commissioner. Commissioner, to that, let me say that I know Justice or President Maya, actually, very well. I've known her from when we were students. I've known her as a colleague. She is a worthy colleague. She is a worthy lawyer, and now she is a leader at a significant level in the judiciary. I would be dishonest to this august body if I were ever to try to take anything away from what I've just tried to highlight about her. That said, I would say I would want to say, let me leave the final decision on that issue with this august body, but clearly and categorically making the acknowledgement that I have made, and which I do not at all make grudgingly, about my colleague, President.
Thank you very much, Justice Madlanga. You've not answered my question, but Acting President, I leave it at that because I did not ask about the other competitors. My question to you was, do you think, is it your view that South Africa is now ready to have a Chief Justice who is a woman? So the question was directed at, refers to the country as you see it right now. Are we ready? And not so much on the candidate, one of the candidates who we are going to interview. But thank you very much. Thank you.
Thank you very much, Commissioner. Thank you.
Justice Madlanga, do you perhaps need a second to answer directly to the question posed to you by Commissioner.
I do not think I can take it further because I do not think I can take it further. I go no further than to say that I leave everything else to this august body.
Thank you, Justice Madlanga.
Let me make a
Commissioner,
Let me make a follow-up, Acting President.
please do. I think by the time we get
Yeah,
to you,
I'll
you'll
be
have
done.
exhausted your questions.
I'll be done because it looks like these questions are coming even before my turn. I don't know, Justice Madlanga, if you are doing yourself a justice. Because they are not asking you for an opinion of this body. They are asking you your opinion, saying, do you think South Africa is ready for a female justice? It's not a question directed at, should this body appoint a female justice? That's not the question. And I liked the way you came earlier on about the LGBTQ community. What happened to that firmness about LGBT? Now that we are dealing with real stuff, the real character is showing up. Because the same stand you took on LGBTQ plus communities, the same stand we take on women. Because all of them are victims of masculinity and all the isms you were speaking about earlier on. It shouldn't be that now that you think you are being put at the corner, you compromise that which came across as your fundamental principles because we are going to doubt them. Now, let me ask the question again. Do you think South Africa is ready for a female justice, Chief Justice?
Oh God, I'm very sorry. I'm sorry, commissioners. I have a strange phone, which even if it's off, it is actually off. If I have an alarm, the alarm goes off even if it's off. I apologize, commissioners. And I don't know how to sort that out.
Maybe it's alarmed by the question.
So this
You are
bell,
forgiven,
this
Justice
bell,
Madlanga.
this bell, unlike in boxing is not saving me, Commissioner Malema. and I had expected this question from Commissioner Malema, and I know how good he is with what the Americans call comebacks. That is, somebody says something and then you clap him. And I had thought that I would say to Commissioner Malema, but of course I was already thinking he would come with a very serious clap. I had thought, Commissioner Malema, I'm actually looking forward to the next elective conference of the EFF, and I want to see Commissioner Malema stepping back and saying, I'm now paving way for a woman commander-in-chief of the EFF. Please don't come with your characteristic comebacks, Commissioner Malema. Commissioner, towards the end of your question, you said otherwise you may even doubt the genuineness of the views that I have expressed. Before answering the question, let me say please don't, and other commissioners as well, and let me also say that it is not just talk. It is there even in my judgments. For example, the Pwanya judgment. For example, the Scripante versus Daniels versus Scripante. For example, the Mukoni judgment, where I came to the assistance of a poor, vulnerable woman. So I do live by those. So whatever happens, it should not be on the basis that you doubt the genuineness of that. Maybe let me just say, I will accept that. I will accept that. But say I have attempted to put myself forward as also a credible candidate and leave it to this commission to exercise its mind as to who it ultimately for whatever reason, for whatever other reason. I have attempted to do the best I can in that regard. But perhaps let me just say I accept that.
Justice Madlanga, we are now looking for a Chief Justice. I think we'll later look for a CIC of the EFF at that time. But for now, we are looking for a Chief Justice. So we'll enter that debate at that time.
There's that comeback.
So, I'm worried, and I respect you dearly. I mean, Dalu will tell you that you are one of the judges that even when you rule against some of us, you do it in such a way that we come out of it learned, educated, and appreciating that we might have missed it here or there. I mean, you used to do it very well with Justice Jafta, I'm told is gone. So the two of you, every time you write judgment, even when you disagree with us, it's so educative. There's nothing that you feel personally attacked or anything of that sort. And a lot of people support women until it comes to them. When it's done there, it's okay. Don't come closer to the office of the CIC, otherwise there's going to be a problem. But on every platform, women must be empowered, women this, women that. Is this not an opportune moment where you say, demonstrating practically beyond the issues of judgment, where I'm not personally involved or affected by that? There are two parties. I'm not a litigating party. I'm making this judgment for these people there who are before me. This is where I can practically make a demonstration of my commitment, even before coming before this body, and say to the president, I really appreciate the fact that you have identified me as one of those people, but I think we need a female now. I mean, 30 years, it's going to be 30 years. There's never been a female Chief Justice. If anything, the judiciary has performed worse than us, politicians, because we have had a vice president, two of them who were females as a country. But never did we have a Chief Justice or even a Deputy Chief Justice who was a female for 30 years. Shouldn't we have reached a point where the male judges who always tell us, and the justices who always tell us they support gender and all that, pen it to the president and say, you know what? We think now is time we get a female Chief Justice, because we've been theorizing about it. Is this not an opportune moment where all of us who say we support females, irrespective of us being identified as potential candidates, say we think a female can be a Chief Justice? Because I'm worried, Justice Madlanga, apart from you, and we know that, apart from you repeatedly saying you leave it to us, you are struggling to say South Africa is ready for a female justice. But in this context, you'll have to look at how we perform. Because we are ready, you can't argue that, but it's not coming out of your mouth. And that's what we are going to argue when we meet. That commitment, that's what makes me now doubt the earlier commitment and the commitment in the judgment. Because a staunch supporter of this will not struggle to say, we are ready for a female Chief Justice. If you were to ask me on the eve of 2024 national elections, where I will be contesting and you say to me, Mr. Malema, don't you think South Africa is ready for a woman president? I will say it's ready. Because South Africa, it is ready for a woman president. So why should I be giving a long explanation instead of just coming out clearly and say, we are ready. We've always been ready. We've led by different capable women in the judiciary. You are even made much better placed to cite their names and say, but in this context, irrespective of what I've said, I'm here, I'm available, and let this body take a decision on what needs to happen. But I hear, and that's what worries me, Acting President, I hear you struggling to commit that South Africa is ready to have a female Chief Justice, and that is really troubling me. I mean, let's leave the fact that there's a candidate who contest you, or you're contesting each other in this, because that candidate might come and perform badly, and you performed better. We'll still appoint you, but it doesn't rule the fact that South Africa is ready for a female Chief Justice. It might not be Judge President Maya. And this process might prove that.
I accepted the proposition, Commissioner Malema. I accepted the proposition.
Thank you, Commissioner Malema, and thank you, Justice Madlanga, for that direct response, because this is what I was also going to take up with you. Thank you.
Thank you, Commissioners.
Commissioner Muimang, the moment that you released has now come. Thank you.
Thank you, Acting President. Good evening, Justice Madlanga.
Good evening, Commissioner.
It's just one area that I thought I must converse with you, though it has three sub-branches. The issue of the composition of the Concord, as alluded to earlier on, in your response, you did indicate the lack of appointment of white male judges in the last 12 years. Am I correct on that?
That was not a point made by me. It was a question posed to me, and it did not say male. It said white colleagues on that bench, and it was asked specifically in the context of Section 174(2), and then my response was, yes, there is a need for all the various categories of the South African populace to feel that the various levels of our judiciary belong to them, and to an extent, I believe that that is what Section 174(2) seeks to address. Yes, of course, then I said quite a lot more than just that.
Thank you. I think the issue of the diversity, it's a very important matter, and the progress that the country has made, particularly at the level of the Concord and the Superior and the Supreme Court of Appeal, I think that progress must be appreciated. Don't you think that we are being too hard on ourselves? I'll tell you why I'm raising this point. The President of the United States of America recently made a proposition that in replacing one of the senior judges whose term has come to an end, it is an opportunity for him for the first time to appoint a woman of color in the Supreme Court in America. And they say that it is for the first time in more than 232 years. That is the context within which I'm saying that are we not being too hard on ourselves, particularly taking from the point that you have raised around the importance of a person's outlook in terms of approaching the issues of transformation. And as a result thereof, what comes to my mind is the outlook of Chief Justice Arthur Chaskalson, Justice Albie Sachs, Justice Didcott, which clearly to me says that as opposed to the United States of America, as a country, we are doing quite well. Hence the question to you is, are we not being too hard on ourselves in terms of the transformation project on the judiciary? Thank you.
I would say yes, we have done well, but I will not go back on the concession I made to the question put to me by Commissioner Malema. I would say we have done far better because unlike the United States of America, in our apex court we have a number of women colleagues.
Thank you. The second leg of my question on the composition, the issue of the term. I know you have canvassed your views on the issue of the term, particularly with regard to whether it is 4 years or 3 years or is it 2 years. The reason why I'm raising this point, just allow me to put my proposition forward. Justice Madlanga. One of the angle that is also in the public domain around this process is the role of the judiciary in the current administration. A concern is raised around the sixth administration appointing judges in the last remaining years of the sixth administration. A point of emphasis being raised to say, if the sixth administration appoint judges when it comes to an end, these judges that are appointed by the sixth administration, come the seventh administration, will they not exert influence in the new administration and exerting influence on two areas? The first one is in the seventh administration, a potential of these judges perpetuating the understanding of the old thinking of the current sixth administration in the seventh administration on key matters of public interest. The second point is the temptation of these judges that are appointed by the sixth administration in the seventh administration using that opportunity to probably correct some of the doctrine that they might not have done in the sixth administration. And this is where an area of judicial activism comes from. So I want to get your views on that.
Commissioner, I do not understand the role of the judiciary to be about either perpetuating the policy of this administration or the policy of the other administration. The Constitution itself, in so many words, says that judges are subject to the Constitution and the law. So judges, regardless of the administration that is in power, are constitutionally obliged to decide cases in accordance with what the Constitution and the law says, whatever the administration. Indeed, I must state the obvious, which is even the oath of office that we take says that is what we must do, apply the law in accordance with the Constitution and the law, and we must do so impartially and everything else. So if the law has been changed by another administration through acceptable legal processes, and that is the existing law, there is no constitutional challenge against it, that is the law that we will apply. If there is a constitutional challenge, it is well grounded, we will invalidate the law regardless of the administration that put it up. I believe that should also deal with your second question about any temptations. We swear allegiance to the Constitution and the law, and I do not think any temptations would come into the equation.
Thank you, Justice Madlanga. Maybe just an elaboration, but it won't necessitate your response. This area that I put to you has been a concern even in America. The judicial process, they say during Obama's administration, he had the same challenge, and they said that challenge was also faced by Nixon's administration during 1969 and 1971. And Roosevelt faced the same in 1937. Of course, mindful of the fact that relatively our constitutional democracy is fairly new, there is a likelihood that maybe in future that could be a possibility. Just the last point now, so that when you respond, at least you also respond to my last question. The judgment that you have referred to as one of your breaking ground, the New Nation movement. As per the judgment, the bill is before Parliament. But what comes to my mind in terms of the thrust of the judgment, which says the route to Parliament and legislature cannot only be through political party, but also through individuals and independent. Just educate to me on that aspect. At the local level, local government level, when an independent or what candidate of a political party passes on, a vacancy is declared and by-election takes place. Now, at the legislature level and also at the parliament level, when that individual or an independent passes away, a vacancy will be declared. But I don't get a sense in terms of how will that independent fill that vacancy because he would have passed on. Maybe if you can just educate me on that aspect. Thank you.
Happily, Commissioner, and this is by no means ducking your question. Happily, all that I had to grapple with was an interpretative process. If, I mean, you're referring to the Roosevelt and Obama and so on administrations in the context of what happens in the U.S. Supreme Court, I would imagine that you have actually read my judgment. If you are, you have that kind of interest, you would have had an interest to read the judgment. If you will see in that judgment how extensively I deal with various sections of the Constitution itself. So my judgment turns on an interpretation of I actually start from section 1, the founding provisions of the code, and I traverse quite a large part of the Constitution into the hundreds, of sections, section maybe 200 and something and so on. A number. So my judgment turns on an interpretative exercise of the Constitution. And I say, not to have this is unconstitutional. And what do I then do with the agreement of the majority of my colleagues? I say, but we suspend this and we send it to Parliament. It is for parliamentarians to then see what they do with that vacancy. It is not for the court. All that I had to do was to say, but this one act that is before me now is unconstitutional. How it gets corrected, we throw it to Parliament. That's their terrain. Otherwise, I, as part of the court, will be straying into their terrain. Separation of powers does not allow that.
Thank you, Justice Madlanga. Thank you, Acting President.
Thank you very much. Thank you very much.
Thank you, Commissioner Moimang. Commissioner Lucas.
Thank you very much, Chairperson, Acting President. Now, a lot have been said about the issues that I would love to went in, like the delays and the issues of women, and even about the 3.5 years. Now, my question is about the issue of, I think we extensively spoke about the issue of delays in the court system, and then about the principle of justice delayed is justice denied. But even yourself, Justice Madlanga, said that you think you are working very hard in the Constitutional Court. My question to you as a candidate that aspire to become the Chief Justice. Oh, okay, I wanted to tell you about the other question that I had before I come to my question. So one of my questions was practically, besides the theory that you wrote about, what have you done to empower women? But I think by now you don't need to respond to that one.
I have done a lot.
We have passed that one. No,
Yeah, I have done a lot, but yes.
The issue is that you have done a lot, yes, in the courts and in your theory. But in terms of making sure that you empower women in the communities to understand how they can use the courts for justice to be done to them, that is exactly what the context of my question would have been. So I want to go further and ask, how are we going to, if you are appointed as a Chief Justice, how are you going to make sure that you have a community that is more justice savvy, that understand better how they can utilize judiciary for a better dispensation for themselves? That is the first part I want to ask and sit back. And also, how will you work on building a cadre of hardworking but also smart-working judicial officials to ensure that really our people get justice and they feel and they see justice to be done to themselves. That will be my questions. Thank you very much, Chairperson.
Thank you, Commissioner. With regard to the issues of communities and access to justice, I would say that there has to be a collective effort on these issues. For example, can't the judiciary partner with, say, because, for example, parliamentarians do constituency work. Some of the parliamentarians are in the Justice Committee. In the collective effort, can't they too just assist in that, the aspect of, the educative aspect? This is not to pass the buck. I'm just saying it may have to be an effort that is much, much wider than focusing on one aspect, just the judiciary. But yes, the judiciary may also play a role in that educative process. Speeches, papers, but it is not practical for the judiciary to go out to several communities. It does not have that same kind of outreach. So I think it would be unrealistic for me sitting here to seriously make promises with regard to what can be done, but something can certainly be done with regard to some forms of outreach, like I say, maybe addresses, lectures, and so on. But the best practical way would be more than just the judiciary being involved, but a broader approach, a collective approach. And I think that that broader or collective approach would better reach the communities. A cadre of hard-working judicial officers. You are able to, you can work hard, but if the situation or the circumstance you find yourself in does not permit you to achieve the sort of outcomes that you achieve, the hard work may take you this far and not that far. An example is what I said, for example, about the delays at the Constitutional Court, which I said were a function of, I identified at least two examples, the deluge of new applications and also just one example of our processes on which I said we now have solutions. So to have a cadre of judicial officers that work hard, but I would also emphasize, but also have the desired outcomes, or are able to bring about the desired outcomes, I would say one would have to to focus on the working conditions, on problems, on bottlenecks, and try as hard as possible to solve those that will then enhance the working environment and improve on outcomes.
I asked these questions to someone that aspired to be the Chief Justice, and I asked these questions to you if you would have been the Chief Justice. But I just want to mention an example of what I think is not smart working.
What is not what?
Smart working.
Smart working, okay.
You are called to the court. You get a letter that says you must be there at 9. 9 o'clock you arrive at the court. It is the time when the officials in the court begin to prepare themselves for your case, which means the only time that you will be able to appear in front of a magistrate is possibly 11 or 12 o'clock. Sometimes people sit there up until 4 o'clock, the court closed. No one inform people that your case will not be in front of us today. So what I'm saying is that attitude or that ethics that need to be built for judicial officials to understand that you must also put in effort, or you must also plan better to be able to serve communities better. I mean, as parliamentarian, you justly said that we are representing communities, and that is why we are here where we are. As Parliament, we were, during lockdown, able for 2 years to do a review across the country, all people. And that is why I'm speaking about this thing, public education and public involvement. Because if you work smart and you plan properly, you will be able to do all these things. I don't want general response. I want the response of someone that have got a vision as to how we are going to make sure that what we are supposed to be doing, it is actually accessible to our people out there. So that is why on some of the things I say don't respond. But on other things I say, build a cadre that they've got an ethic of service delivery and that want to make sure that they educate our communities. Because even through the process in the court, you can educate people. But sometimes you go to court, you don't understand even where you must go, you don't even know what to do. Particularly some of us never went to court in our life when we were younger. Now that we are older, sometimes we clap people and we are being taken to court. And then you don't even know what to do. I'm just mentioning it. Thank you.
Commissioner, thank you. I would like to respond, and thank you very much that you actually gave a concrete example, because when a question is asked in broad terms like that, it may be difficult for you to grapple with it in practical terms as well. I like responding by making reference to myself. Let me do that here as well. When I was a high court judge and therefore sat all by myself, except in those instances where I would be part of a panel on appeal, court started at 10 then, not even the 9 o'clock that you are referring to, the high court. If at something like 3 minutes to 10, the court orderly had not come to fetch me, I would walk out of my office, go straight to the courtroom, enter without that court rise and all that announcement, and go and sit down. And everybody would jump and run around, and I would not get out until everybody got organized and started doing something, or began with the business of the day. Where am I going with that? If that is how my own makeup is as a Chief Justice, this is something that I would not only be willing to, but that I would actually sell, and I would go to the right levels of the judiciary to make sure that there is the kind of cadre that you are talking about, Commissioner. And this would come naturally in my case. Thank you.
Thank you, Commissioner Lucas. Commissioner Breitenbach.
Thank you very much, Acting President. Good afternoon, good evening, Justice Madlanga.
Yes, Commissioner.
You must be really tired having...
Very, very, Commissioner.
Not sure how fair it is to subject you to such a long period.
I was part of this body when we subjected Chief Justice Mogoeng to 2 days of this. So maybe I should not complain.
My sympathy for you is just evaporated. Justice Madlanga, your views on access to justice are terribly exciting, and I support them 100%. And there are members of the Portfolio Committee on Justice on this body, and the chairperson, in fact, of the Portfolio Committee is there with you, and the Minister is here with you. So I think between us, we can actually try and do something about that. I think it's a worthwhile project.
Thank you, Commissioner.
One of the consequences of questioning you so late in the day, of course, not sure if it's an advantage or disadvantage, is of course that most of the questions have been traversed. And I'm a great admirer of brevity, and so I will not re-ask any of the questions that have been asked.
Yes.
What I would like to take up with you is if you are appointed, how do you propose to properly and efficiently close the gap between the Superior Court Judiciary and the Lower Court Magistracy in order to promote unity, mutual respect, and an efficient delivery of justice within the component of the judiciary?
Thank you, Commissioner. Even though I stated it very, very briefly, it is one of those issues that I want I would, if appointed, I would focus on. I touched on the fact that the two main points that I've been able to identify, but there's certainly probably more, that the magistracy is raising are the question of a move from the Department of Justice, one, and then the question of what has been referred to as integration. I am for the idea of integration, in the sense that we should be one judiciary in the true sense, but that can not mean that we will not have the levels that we have, because we do have the magistracy, which itself is at 2 levels. Those will continue to be realities. And also the appointment processes, it may perhaps not be practical to use the same body. Imagine there are more vacancies in the magistracy, and this body, if it were to be one body doing all the appointments, there would be nothing that you would ever do. You would be coming here, maybe at one session you are appointing many magistrates and many judges, and then because there are vacancies all the time, this would probably be all that you would ever be able to do. So integration, yes. One umbrella, yes. But all of these to be done with a recognition of the reality that there are different levels and coming up with practical ways of how to address or to work with the reality of those two differences, different levels, but under one umbrella, one judiciary. Yeah, I would leave it at that, Commissioner.
Thank you very much. Thank you. That's all my questions.
Thank you. Thank you, Commissioner.
Thank you, Commissioner Breitenbach. Commissioner Barnett.
Thank you, President. Good evening, Justice
Good,
Madlanga.
good evening, Commissioner.
Justice Madlanga, my question relates to access to justice and actually in an interesting way latches onto the question of a few of the commissioners that just came before me. Access to justice and specifically the small claims court. Now, if one, you spoke about courts down to the magistrates court level and district level. I think that was the lowest I've heard you speak so far. But if one now thinks about Section 165 of the Constitution, which gives the responsibility to the Chief Justice over the judicial function of all courts. I want to highlight the all courts aspect of it. This includes what Section 166E refers to as any other court that is other than higher and magistrates courts. So we're talking really about courts closer to the communities even than those that you refer to. How do you see the role of Chief Justice, if any at all, in, for example, the small claims court where many citizens get access to justice? In fact, at the time that I'm speaking to you now, there are probably some small claims courts functioning at the moment with people coming from work and then attending courts and so on. And where many lawyers sit as commissioners. So how do you see your role? Do you have a vision for that as well?
Because even though this was years back, this is something that I have actually seen work, and when I say years back, it really is years back. This is when I was doing pupillage, and the advocate I was doing pupillage under was a commissioner in a small claims court, so he used to go there, and I would go with him in the evenings after work, and I would just sit at the back. And in practical terms, I actually saw how well the system works. And of course, then the monetary jurisdiction was quite low. It still is low even now, but it is much, much better now. And you are quite right to say that that is a system that works with access of justice. And I recently had occasion to actually go through the Act, and it makes the process quite accessible. It does away with the clutter of formal processes and so on. It's so easy, in fact, that a non-lawyer who can read the Act can be able to start their own case, lodge it with a small claims court, and be able to run with it. But of course, with people who cannot read and be able to do it themselves, efforts would have to be made to educate people about it. It is, I agree with you, a very useful access to court tool. It would just have to be used optimally. Are you not muted, Commissioner?
Thank you. Sorry about that. I think the initial act was something like 36 years ago, and there's been some amendments being worked on and so on. But what I actually want to hear is your vision. Is there any vision or thoughts on integration of this
I would say that as long as the idea of integration does not bring within that court the sort of traditions that we know to exist within the other components of our court system. So if in essence it stays the same, I mean, the very idea that it has been sold to practitioners to participate in it as commissioners free of charge is in itself quite a benefit to the poor and the vulnerable who have ready access to court. So as long as the idea of integration will not unfortunately bring some of the problems that that make the rest of our court system inaccessible, I would have no problems with that idea. But as to what the actual integration would entail, we should protect.
Thank you. My second question I'll leave due to the time constraints, but I'd like to move on to a third aspect, and possibly the last thing that I would deal with today, and that is, I see in paragraph 21 of your application that you also function as a lessor of properties, whether directly or indirectly, so rental properties now. And then I noticed in your judgment in Daniel versus Spimante, where you draw extend the ESTA legislation and rights of the occupant of a property to be able to make changes where even against the wills of, or against the will or the wishes of whoever owns the property. So I was just wondering, in your context as a lessor, some of the contracts, the standard leasing term would be not to allow someone to make changes to the property without the owner consenting. So, do you think that this type of judgment opens the way for a overall rethinking of that clause on a constitutional level?
I think that a crucial aspect of my judgment, which was centered on dignity, the right to dignity, was the fact that it was in the context of Esther. This is somebody who is entitled to live here on this farm in terms of an act of parliament that seeks to address. In fact, in a sense, Esther is at the heart of deprivation. You will have seen in that judgment, I actually open with the words of Mr. Nkosi, who says, and I'm paraphrasing and summarizing seriously, but the substance of what he says is, without land, we are nothing. So that was the context, and then you will see I go at length into the history of land dispossession in the country. So I think what I say in that judgment should be viewed in the context of what it was about. This poor lady is on this piece of land. She's not asking to break down walls, take off the roof. All she was asking was, I want to be able at night, if I want water and I've forgotten to fill up my bucket, I don't want, if I want to drink, to go outside. I want to have a tap inside this house. I want to replace this window. I want to level the floors in this. All she was, and you should bear in mind in that case, Commissioner, that the respondents, the farm manager and the farm owner, did not dispute what she said she wanted. And she wanted to do it out of her own pocket. But they just said, no, we will have none of that. And I said, effectively, this makes nonsense of Esther. This makes nonsense of a constitutional or a constitutionally guaranteed right that she enjoys. And that goes to the question of dignity. And I said, based on that, she is entitled to do what she said she wanted to do out of her pocket, even if the owner did not give permission.
Thank you very much. Those are my questions.
Thank you, Commissioner. Thank you very much.
Thank you, Commissioner Barnett. Commissioner Malema.
Thank you, Acting President. Justice Madlanga, I just want to ask, I know you dealt with that in your questionnaire, of going to the bench and going back to be an advocate. I find it very strange. Please take us through.
Yes. Commissioner, I had gone to the bench or come to the bench fairly young. Well, I may be criticized, maybe at the level of, well, that was not a sound judgment on my part, and if somebody says so, maybe I will not try to argue against that. I came to the bench fairly young. At the time I did, I was the youngest judge in South Africa. I was 34. Some may say 34 is old. I had a young family, and you know what that entails in terms of expenses and so on and so on. And after about 5 years, I just could no longer. And I was quite public about this. I was never even secretive about it. It was not, the sort of silent, resigned for what's the term that's normally used, personal reason or something like that. Fine, I did not make a public statement, but I was open about it. The minute I felt, no, I can no longer stand it, I was acting at the Constitutional Court at the time. I went to President Shaskalsin. I explained everything to him. I was open with him. I didn't just say personal reasons, no, I'm out. And then I made an appointment with the minister then was Minister Penwell Maduna. I also spoke to him, fully explained and gave him the same facts that I've just given to you now. Both of them did try to say, no, please don't. And I understood where they were coming from, but unfortunately, Commissioner, the reality was I just could no longer go on. It was, to cut a long story short, those, unfortunately, and I left it was not for any lack of love for the job. I still liked what I was doing. I would have stayed on, but it just became impossible. And rather than reach a point where it would, I'm not saying I would have done anything improper, but it could have reached a point where it just becomes, horrible for me in the sense that there's the judge getting sequestrated or something like that. Those were the facts, Commissioner.
Why did you come back?
Oh, I'm sorry for the laughter. I still remember the dates, Commissioner Malema. I was on holiday in December, late December after Christmas, late 20s, close to the end of the month, and I was called by, I hope my colleagues will not feel embarrassed about me revealing this. And I was called by the acting Chief Justice. He was still the Judge President of the Labour Court, but he had acted at the Constitutional Court. And he said there was something he wanted to talk to me about. And I said, well, fortunately I was on holiday in Durban. I said, I am in Durban, and he came to me to see me. It was on the 1st of January 2012, I think. And he broached the subject with me and said, haven't your circumstances changed now? And even before I left, he had been wanting me to go to act at the Labour Appeal Court. He was really sitting on me. So that's the level at which he respected me as a colleague and as a judge. And so he said, as a colleague who knew me and who respected me, did I not think that it was now time to come and rejoin them as colleagues on the bench? And then on the 18th of February, and with him having called me a few days before, I met my colleague whom you mentioned, Justice Chapter. He also asked to meet me. I met him on the 18th of February that same year, and he too broached the same subject. I might mention that other colleagues as well, a friend of mine who is a judge in Port Elizabeth, Judge Mandela Makaula, had been talking about the same thing quite a number of times. But you know how sometimes you treat friends. I never took my close friend. I mean, he comes from my hometown, grew up as a young Bafana together. I would just tell him to, get off. So I then started thinking about it quite seriously, Commissioner, and I think that did weigh heavily with me.
My question is, why did you come back? You left because you had personal circumstances that led to you leaving. So your coming back meant that those circumstances have changed for the better, to avoid having a judge being sequestrated.
I felt I was comfortable to come back, Commissioner.
So you came back in February?
No, to join the court. No, that was meeting Justice Chapter on the 18th of February 2012. I was then appointed with effect from the 1st of August 2013.
Now, do you think that judges must go to the houses of politicians? Do you think it is correct for judges to go to the houses of politicians and later say, no, I had visited the house of a politician because there was a matter of national importance that I wanted to discuss with this politician? But you can't take the country into confidence as to what are those matters of national importance that makes you visit politicians in their houses. Do you think that helps to enhance the good image of the judicial?
I would say, to the extent that the situation may create suspicion, perceptions, and so on, I would say it is not right. But at the level of whether or not you should go at all, I would say, I mean, we know there are politicians that I know at a personal level, and I would have no problems with them coming to my house, and I would have no problems at all going to their houses. But I again emphasize, and my understanding is that what you raise with me is at the level of a possibility of a perception that may even create possibilities of does this not get to the level of a lack of impartiality? You know, those sort of negative perceptions that should not exist around the judiciary. If it is something that would raise those sort of problems, I would say then there is something wrong with it.
No, I understand the one of friendship and all of that. We live in the same society. We have gone to school together and all manner of things. But a point where it comes out later that you visited a politician, and when you are asked, what were you doing in that politician's house? You say, no, we're discussing a matter of national importance. So meaning you have a secret with a politician as a judge. And when that type of a meeting is exposed, you are still not in a position to take the country into confidence. Does it help to build the confidence of society on our judiciary, where a judge can have a secret with a politician, and when exposed, you still don't want to reveal that type of a secret? Does it help to enhance the good image of the judiciary?
Anything, Mr. Malema, including that example, it could even be a different example, anything that could create the impression of, the possibility of an association that may create a perception of lack of impartiality, lack of independence, is deleterious to the idea of an independent judiciary.
I don't know if I heard you properly, Justice, about, you said the Chief Justice must be, no, I'm on something else, I'm done with that one. You said Chief Justice must be a judge and not be this super SG, and plus you don't want to claim that you understand the administrative role of a Chief Justice, you don't know. Are you saying you are applying for a position where you don't know, apart from being a judge, what is required or what are the duties of this Chief Justice administratively? Because I had to say you don't know those responsibilities, you don't want to be claiming to know them, because more than being a judge now, we are looking, because the judge's story and a judge of a constitutional court is out, that one. We know you can be, and we have no doubt about it. Now we're looking for a leader who's going to have to be not only a judge, but also lead administratively to make sure that this court runs effectively, not only the court, the whole of judiciary. And key amongst those will also include the spending. Because I had someone saying to you, don't like budget. And leadership is budget. Whether you are a president of South Africa or not, you can't have a minister of finance. You can't prevail over and make sure that all of those things are done accordingly, because let's say the SG misuses the funds, it's going to come back to you. Because as you are speaking about the SG of the Constitutional Court, I'm trying to imagine even the picture. I can't even think of that person, who's this person. All I'm thinking of with the Constitutional Court, mokwe. So if anything goes wrong, whether you are interfering or you don't interfere, whether you like the budget or don't like the budget, it's going to come back to you as a leader of that institution. So please make me comfortable about that, because I had to say, you don't know the administrative roles, you don't want to interfere, you don't want to be a super SG, and therefore some of those things will leave to people that were not subjected to this. And as a leader, you take full responsibility, including the mistakes of the SG, they come back to you.
Thank you, Commissioner Malema. If I created an impression of being clueless as to what the Chief Justice does administratively, that was not intended. Because if that were the case, I would not have been in a position to attempt in what I believe was a fairly detailed manner to even set out a vision as to how certain issues should be addressed in future. I do have an idea of the sort of administrative or leadership issues that relate to and can be performed by a Chief Justice. And some of them are even, for example, in the Judicial Service Act, Superior Courts Act, and even the Constitution. One of the commissioners who were online actually referred me to the norms and standards that, in terms of the Constitution, must be set up by the Chief Justice. What I was seeking to address with regard to what I do not know, and which should be hopefully, Commissioner Malema, be acceptable, because I have not been exposed to that as an ordinary judge of the Constitutional Court. What I was seeking to refer to was the possibility of other administrative functions that may well be out there as well. And it is those that I was trying to refer to. It was by no means saying I, as a Chief Justice, if appointed, I would shirk the responsibility with regard to those that I say are clearly within the remit of the Chief Justice. With regard to the budget, that too, I just said, it's something that I will apply my mind to. It is something that I am even willing to consider what the best practice internationally is on it. That is, who in other jurisdictions, in particular comparable jurisdictions, say in Africa, yes, of course, I could look elsewhere as well, who within those judiciaries, for example, I first heard the idea of an administration that is attached to the court and removed from the other executive functions. I first heard of that idea from a colleague from Mozambique when I was a judge earlier. We knew nothing about that in South Africa at the time. So one can learn even on issues about how our budgets are administered from what other countries do. So it was not a question of an outright rejection of the idea. I guess it was more a question of saying, managing monies. But I did say, if you remember, Commissioner Malema, I did say, but of course, the reaction that I have given, which I'm not, without rejecting your idea, Commissioner Singh, the idea in no way suggests that I am averse to being involved at all on budgets. I said, because the OCJ services the judiciary, and because the Chief Justice is the head of the judiciary, it makes practical sense for the Chief Justice to have an input on the OCJ's budget. And of course, it would not be only the Chief Justice, other heads of courts at all levels would also have to have an input.
Justice Madlanga, as you speak about learning these administrative components that we may not be aware of, I put another 6 months to 1 year of you learning that into these 3 years. And then I put another 3 to 6 months of you learning in the outside world how the budget works. And you are left now with 1 year, 6 months before you do the actual thing, just learning. Because if you ask us, politicians, when you assume office, the most difficult thing, she's there, she's a speaker. She is not old in that position. For sure, she's still grappling with a lot of small detail. Some she even gets shocked, oh, he's done this way or that way. By the time she becomes well equipped as a speaker, it's 2024, we're going to elections. Because to learn administration must never be confused to be meaning some simple thing, or you are just going to arrive at an office where you are going to be welcomed with both hands. You are going to have to learn these people and do all manner of things, which I thought Justice Madlanga would have done some small research, even if you are a junior. Not junior, I don't want to call you such things. What judge, not in the office of Chief Justice, but an ordinary judge. But preparing for this type...
It's not puny, not at the level of
Yes.
the Constitutional Court.
Yeah, so
sorry, Commissioner Malema.
as an ordinary judge,
Yes.
who's now preparing to go into that office, you would have said to us, apart from this that is described in the Constitution and the norms and standard and all of that, these are the issues administratively we're going to have to deal with. And on matters of budget, you would have also looked at what happened to the previous Chief Justice and what are the issues that you want to take up immediately when you take over. Because we don't want to hear of a scandal of corruption coming out of the office of the Chief Justice, because our Chief Justice doesn't know how the budget in that office operate. In that 6 months when you are still trying to learn, you know these people of South Africa, already they've approved the IT tender. It's gone and it's not done properly. So, because I'm going to raise these points when we retreat on Saturday, that I'm worried about these issues, that you are going to be this good judge and get destroyed by this small detail that you have not given yourself sufficient time to acclimatize yourself with or have an idea of how you're going to deal with it, because it's very big. It might be small, but it's a very big operation which makes that office run on a daily basis.
On the first issue about the possibility of a long time being taken, finding out what happens in other jurisdictions with regard to the budget, I would say that the time cannot be long at all. I mean, if appointed, I will have ready access to Chief Justices in other countries, pick up the phone and just ask the question, pick up the phone, talk to another Chief Justice. Within a few days, you have the information readily at hand. For example, I said earlier that we found what the situation is with regard to turnaround times for handing down judgments by apex courts. We were tasked by our colleagues to do this, to work on the working procedures, revise the working procedures of the Constitutional Court. Second half of last year, by the 5th of December, we already had a completed document, which of course we are just crossing the T's, dotting the I's on now, but we're able to pull out one recommendation for immediate implementation. But even there, we had to go out to other jurisdictions on information, and we were able to come out with a document within a very short space of time. Second half, by December, we have something ready. And on this one, and if I'm Chief Justice, I will be able to just pick up the phone, who controls the budget and how. Even on the second one, Commissioner, I do not share your view that it would take a terribly long time for me to get around the question of I have interacted with the Secretary General in contexts that, of course, have nothing to do with being Chief Justice, which I am not. And the Secretary General is very cooperative, very supportive to the judiciary. Immediately upon appointment, I would set up an appointment with her, and she would take me through the processes. And I think you heard me when I was talking earlier about, getting up to speed on, I even rattled off a few principles, in the sort of areas of law that we as black people would not be exposed to, talking about inutility, lack of innovativeness, and so on and so on. Things that you would be getting to hear about now for the first time. But you would quickly, get on top of them and be able to participate effectively. And even when a case is argued before the court, you saw this for the first time now, you read the papers, you went outside of the papers, did your own research quickly, and in court you are able to engage advocates sensibly and meaningfully. So even with this, I do not believe that for me it would be something that would take me 6 months, and I do not believe it would, Commissioner.
My last question is, do you think commissions of inquiry add value in a democratic South Africa, or is just a waste of money? Or they are used by politicians to buy themselves time so that they can lull society and not be held accountable? Because I'm trying to think of any successful commission of inquiry since 1994. I can't think of any. Successful in a sense that when it concluded its work and made recommendations, there was serious follow-up and action was taken. There's no such. And as a result, a lot of money gets to be used in those commissions of inquiry. And lawyers just line up their pockets and make money out of the taxpayer. But we don't see results of those commissions of inquiry. I mean, I'm asking this because you were in the Marikana Commission. There was a commission on arms deal. I don't know what is happening, where. So I'm trying to think, are these things really relevant for? I know they have a space in terms of the Constitution of the Republic and all of that, but have they really added value in our democratic society, or they were just used to buy time so politicians can lull society and lawyers make money out of it?
You see,
I know Mr. Mpofu and them won't agree with the money part.
Commissioner Malema, for reasons based on what you prefaced the question with and also what you ended the question with, may I ask, please, not to answer the question, because you say so many ways, politicians do this, and you will remember that I repeatedly said here that we as judges should avoid engaging in political controversy. May I please ask to...
Let me ask it differently then. Let me leave politicians.
I had to expect that.
Do commissions of inquiry add value in our judiciary or in our democratic society? Since 1994, have they played any significant role which helped ordinary people to receive justice?
Of the few that I can think of, I cannot think of something that has tangibly redounded to the benefit of people. I cannot think of any.
Thank you, Justice Madlanga. Thank you, Acting President.
Thank you.
Thank you, Commissioner Malema. Justice Madlanga, I've got two issues that I would like to canvass with you before we conclude. And you already touched upon them earlier, but I'm coming from a different perspective. The first one is that South African judges come from various backgrounds, and the broad proposition that I want to put to you, which will call for a simple answer, yes or no, is this. Regardless of their past political affiliations, judges are expected to be scrupulously faithful to their oath of office and decide cases that come before them on their merits with integrity, courage, by applying the law to the facts. Do you subscribe to that statement?
Yes, I do.
And the second one, and the last one, and you did allude to it earlier, that it is an illusion to think that the Chief Justice is a supernatural being with a monopoly of wisdom who will have all the answers for everything. And an astute Chief Justice will recognize that within the judiciary, as anywhere else for that matter, there will be judges with special skills and talents, and indeed leadership qualities, and a Chief Justice of that kind would then be well advised to tap on these talents and skills for the good of the institution.
Yes.
And lastly, and we are now at the tail end of the interview, do you have anything else you would wish to say that may, in your view, be of assistance to us during our deliberations?
I think I have said everything I ever could, Acting President. All I would do is to thank the commissioners, all without exception, for the manner in which I was engaged. But there's nothing else I want to add, Acting President.
Thank you. Then it remains for me to thank you most sincerely for availing yourself and for your answers to the questions which were posed to you by the members of the commission, which will be taken into account during our deliberations on Saturday.
Thank you. Thank you.
You are now excused.
Thank you.
Thank you.
Thank you.
Please call the next candidate, please.
You are usurping my powers, Commissioner Malema.
No, Chair, I'm just saying we're ready for the next one.
Thank you. Fellow commissioners, we have now come to the end of our business for the day, and this is now an opportune moment to adjourn until tomorrow morning at 9 o'clock on the dot, when the next candidate will be interviewed. And thank you very much for your cooperation, and go and retire now and come back tomorrow fully refreshed. Thanks very much.
Thank you, Chair.